and does not lose his Philippine citizenship unless he renounces it. Electing Philippine citizenship. 1. Attorney Emily Go, a legitimate daughter of a Chinese father and a Filipino mother, was born in 1945. At 21, she elected Philippine citizenship and studied law. She passed the bar examinations and engaged in private practice for many years. The Judicial and Bar Council nominated her as a candidate for the position of Associate Justice of the Supreme Court. But her nomination is being contested by attorney Juris Castillo, also an aspirant to the position. She claims that attorney Emily Go is not a natural-born citizen, hence, not qualified to be appointed to the Supreme Court. Is this contention correct? Suggested answer. The contention is not correct. Under Article 4, Section 1 of the 1987 Constitution, it is provided that those born before January 17, 1973 of Filipino mothers, who elect Philippine citizenship upon reaching the age of majority are Filipino citizens. Attorney Emily Go was born of a Filipino mother in 1945 and elected citizenship upon reaching the age of 21. She is a natural-born Filipino citizen as provided by Article 4, Section 2 of the Constitution XXX. Those who elect Philippine citizenship in accordance with paragraph, Section 1 hereof shall be deemed natural-born citizens. Hence she is qualified to be appointed to the Supreme Court. Electing Philippine citizenship, when proper. 2. Attorney Richard Chua was born in 1964. He is a legitimate son of a Chinese father and a Filipino mother. His father became a naturalized Filipino citizen when attorney Chua was still a minor. Eventually, he studied law and was allowed by the Supreme Court to take the bar examinations, subject to his submission to the Supreme Court proof of his Philippine citizenship. Although he never complied with such requirement, attorney Chua practiced law for many years until one Noel Eugenio filed with the Supreme Court a complaint for disbarment against him on the ground that he is not a Filipino citizen. He then filed with the Bureau of Immigration an affidavit electing Philippine citizenship. Noel contested it, claiming it was filed many years after attorney Chua reached the age of majority. Will attorney Chua be disbarred? Explain. Suggested answer. No, attorney Chua will not be disbarred. Attorney Chua is already a Filipino citizen and there was no need for him to file the affidavit electing Filipino citizenship. An election of Philippine citizenship presupposes that the person electing is an alien. His father, however, already became a Filipino citizen when attorney Chua was still a minor and thus, he was already a Filipino before the age of majority. Natural-born Filipino. No. 2. A child was born to a Japanese father and a Filipina mother. Would he be eligible to run for the position of member of the House of Representatives upon reaching 25 years of age? Suggested answer. The child can run for the House of Representatives provided upon reaching the age of majority he elected Philippine citizenship. Under Section 6, Article 6 of the 1987 Constitution, to qualify to be a member of the House of Representatives, one must be a natural-born Philippine citizen. According to Section 1, Article 4 of the 1987 Constitution, children born before January 17, 1973 of Filipino mothers, who elect Philippine citizenship upon reaching the age of majority are Philippine citizens. Section 2, Article 4 of the 1987 Constitution provides, those who elect Philippine citizenship in accordance with paragraph, Section 1 hereof shall be deemed natural-born citizens. On the other hand, if the child was born after January 17, 1973, he would be considered a natural-born citizen without need of election pursuant to Art. 4, Sector 1. Natural-born Filipino. No. 4. Andres Ang was born of a Chinese father and a Filipino mother in Sorsogon, Sorsogon. On January 20, 1973, in 1988, his father was naturalized as a Filipino citizen. On May 11, 1998, Andres Ang was elected representative of the 1st District of Sorsogon. Juan Bonto, who received the second highest number of votes, filed a petition for quo warranto against Ang. The petition was filed with the House of Representative Electoral Tribunal. Bonto contends that Ang is not a natural-born citizen of the Philippines and therefore is disqualified to be a member of the House. The HRET ruled in favor of Ang. Bonto filed a petition for certiorari in the Supreme Court. The following issues are raised. Whether the case is justiciable considering that Article 6. Section 17 of the Constitution declares the HRET to be the sole judge of all contests relating to the election returns and disqualifications of members of the House of Representatives. Whether Ang is a natural-born citizen of the Philippines. 5%. How should this case be decided? Suggested answer. 1. The case is justiciable. 2. Andres Ang should be considered a natural-born citizen of the Philippines. He was born of a Filipino mother on January 20, 1973. This was after the effectivity of the 1973 Constitution on January 17, 1973. Under Section Article 3 of the 1973 Constitution, those whose fathers or mothers are citizens of the Philippines are citizens of the Philippines. Andres Ang remained a citizen of the Philippines after the effectivity of the 1987 Constitution. Section 1, Article 4 of the 1987 Constitution provides, the following are citizens of the Philippines: those who are citizens of the Philippines at the time of the adoption of this Constitution. Natural-born Filipino. Number 1, in 1964, Rufa, a Filipina domestic helper working in Hong Kong, went to Taipei for a vacation, where she met Cheng Xiaopao, whom she married. Under Chinese law, Rufa automatically became a Chinese citizen. The couple resided in Hong Kong, where on May 9, 1965, Rufa gave birth to a boy named Ernest. Upon reaching the age of majority, Ernest elected Philippine citizenship. After the EDSA revolution, Ernest decided to live permanently in the Philippines, where he prospered as a businessman. During the May 11, 1993 election, Ernest ran and won as a congressman. His opponent, noting Ernest's Chinese ancestry, filed a petition to disqualify the latter on the following grounds: Ernest Cheng is not a natural-born Filipino, and he is underaged. Decide. Suggested answer. 1. Ernest cannot be disqualified. Section 1, Article 4 of the Constitution provides, the following are citizens of the Philippines: XXXXXX. Those born before January 17, 1973, of Filipino mothers, who elect Philippine citizenship upon reaching the age of majority. Ernest could elect Philippine citizenship since he was born before January 17, 1973 and his mother is a Filipino. As stated in the cases of Torres vs Tan Chim, 69 Phil. 518 and CU vs Republic, 83 Phil. 473. For this provision to apply, the mother need not be a Filipino citizen at the time she gave birth to the child in question. It is sufficient that she was a Filipino citizen at the time of her marriage. Otherwise, the number of persons who would be benefited by the foregoing provision would be limited. Having elected Philippine citizenship, Ernest is a natural-born Filipino citizen in accordance with Section 2, Article 4 of the Constitution, which reads, "Those who elect Philippine citizenship in accordance with paragraph, Section 1 hereof shall be deemed natural-born citizens." 2. Ernest is not underaged. Naturalization, cancellation of citizenship. No X, Lim Tong Biao, a Chinese citizen, applied for and was granted Philippine citizenship by the court. He took his oath as citizen of the Philippines to July 1963. In 1975, the Office of the Solicitor General filed a petition to cancel his Philippine citizenship for the reason that in August 1963, the Court of Tax Appeals found him guilty of tax evasion for deliberately understating his income taxes for the years 1959 to 1961. Could Lim Tong Biao raise the defense of prescription of the action for cancellation of his Filipino citizenship? Supposing Lim Tong Biao had availed of the tax amnesty of the government for his tax liabilities, would this constitute a valid defense to the cancellation of his Filipino citizenship? Suggested answer. 1. No, Lim Tong Biao cannot raise the defense of prescription. As held in Republic Us. Go Bon Li, 1 SCRA 1166, 1170, a decision granting citizenship is not residential judicata, and the right of the government to ask for the cancellation of a certificate cancellation is not barred by the lapse of time. 2. The fact that Lim Tong Biao availed of the tax amnesty is not a valid defense to the cancellation of his Filipino citizenship. In Republic vs. Li Yao, 214 SCRA 748, 754, the Supreme Court held. In other words, the tax amnesty does not have the effect of obliterating his lack of good moral character and irreproachable conduct, which are grounds for denaturalization. Residency requirements, elective official. In the May 8, 1995 elections for local officials whose terms were to commence on June 30, 1995, Ricky filed on March 20, 1995 his certificate of candidacy for the office of Governor of Laguna. He won, but his qualifications as an elected official was questioned. It is admitted that he is a repatriated Filipino citizen and a resident of the province of Laguna. To be qualified for the office to which a local official has been elected, when at the latest should he be a Filipino citizen? Explain. Suggested answer. The citizenship requirement is to be possessed by an elective official at the latest as of the time he is proclaimed and at the start of the term of office to which he has been elected. Section 39 of the Local Government Code, which enumerates the qualifications of elective local government officials, does not specify any particular date or time when the candidate must possess citizenship. A resident of the locality? Explain. Suggested answer. Under Section 39 of the Local Government Code, an individual must possess the residency requirement in the locality where he intends to run at least 1 year immediately preceding the day of election. Status: illegitimate child. Number 3. Y was elected senator in the May 1987 national elections. He was born out of wedlock in 1949 of an American father and a naturalized Filipina mother. Y never elected Philippine citizenship upon reaching the age of majority. Before what body should T, the losing candidate, question the election of Y? State the reasons for your answer. Is Y a Filipino citizen? Explain your answer. Suggested answer. T, the losing candidate, should question the election of Y before the Senate Electoral Tribunal. Yes, Y is a Filipino citizen. More than that, he is a natural-born citizen of the Philippines qualified to become a senator. Since Y is an illegitimate child of a Filipino mother, he follows the citizenship of his mother. He need not elect Philippine citizenship upon reaching the age of majority as held in Remalarat. 59 SCRA 45. In Osius v. Antonino, Electoral Case No. 11, August 6, 1971, the Senate Electoral Tribunal held that the illegitimate child of an alien father and a Filipino mother is a Filipino citizen and is qualified to be a senator. Status: illegitimate child, dual citizenship. Number 8, 2. X was born in the United States of a Filipino father and a Mexican mother. He returned to the Philippines when he was 26 years of age, carrying an American passport, and he was registered as an alien with the Bureau of Immigration. Was X qualified to run for membership in the House of Representatives in the 1995 elections? Explain. Suggested answer. Whether or not X was qualified to run for membership in the House of Representatives in the 1995 election depends on the circumstances. If X was an illegitimate child, he is not qualified to run for the House of Representatives. According to the case of Enri Malarat, 59 SCRA 45, an illegitimate child follows the citizenship of the mother. Since the mother of X is a Mexican, he will be a Mexican citizen if he is an illegitimate child, even if his father is a Filipino. If X is a legitimate child, he is a Filipino citizen. Under Section 2, Article 4 of the Constitution, those whose fathers are citizens of the Philippines are Filipino citizens. Since X was born in the United States, which follows jus soli, X is also an American citizen. In accordance with Osnar vs. Commission on Elections, 185 SCRA 703, the mere fact a person with dual citizenship registered as an alien with the Commission on Immigration and Deportation does not necessarily mean that he is renouncing his Philippine citizenship. Likewise, the mere fact that X used an American passport did not result in the loss of his Philippine citizenship. As held in Kawakita vs. Untold states, 343 U.S. 717, since a person with dual citizenship has the rights of citizenship in both countries, the use of a passport issued by one country is not inconsistent with his citizenship in the other country. Alternative answer. If X has taken an oath of allegiance to the U.S., he will be deemed to have renounced his Philippine citizenship. Consequently, he is disqualified to run for the House of Representatives. Status: legitimate child. No. 4. Miguel Sin was born a year ago in China to a Chinese father and a Filipino mother. His parents met in Shanghai, where they were lawfully married just 2 years ago. Is Miguel Sin a Filipino citizen? Suggested answer. Miguel Sin is a Filipino citizen because he is the legitimate child of a Filipino mother. Under Article 4, Section 4 of the 1987 Constitution, his mother retained her Philippine citizenship despite her marriage to an alien husband, and according to Article 4, Section 1 of the 1987 Constitution, children born of a Filipino mother are Filipino citizens. Ways of reacquiring citizenship. No. 18. Cruz, a Filipino by birth, became an American citizen. In his old age he has returned to the country and wants to become a Filipino again. As his lawyer, enumerate the ways by which citizenship may be reacquired. Suggested answer. Cruz may reacquire Philippine citizenship in the following ways. 1. By naturalization, 2. By repatriation pursuant to Republic Act No. 8171, and 3. By direct act of Congress. Article 6 Legislative Department. Appropriation of public funds. Number 6. metropolitan newspapers have reported that the Philippine Games and Amusement Corporation gives hefty contributions to Malacanang, to fund socio-economic and civic projects of the President. The reports add that for 1988 alone, some 600 million pesos have already been earmarked for remittance to the office of the President. PGR had also been reported to have funded, as coordinated by a congressman from Mindanao, special projects of quite a number of members of the House of Representatives. Assuming that money earned by PGR from its operations are public funds, are such contributions to Malacanang and to certain congressmen and their expenditure as reported, legal? Cite constitutional or decisional rules in support of your answer. Suggested answer. The contributions made to Malacanang and to certain congressmen are illegal. Under Art. 6, Section 29, no money can be paid out of the Treasury except in pursuance of an appropriation made by law. The disbursement of public funds by PGR, not being made pursuant to an appropriation made by law, violates the Constitution. Appropriation of public funds, debt servicing. Number 13. Explain how the automatic appropriation of public funds for debt servicing can be reconciled with Article 6, Section 29 of the Constitution. Said provision says that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Suggested answer. As stated in Ginguna vs. Karaki, 196 SCRA 221, the presidential decrees providing for the appropriation of funds to pay the public debt do not violate Section 29, Article 6 of the Constitution. They provide for a continuing appropriation. There is no constitutional prohibition against this. The presidential decrees appropriate as much money as is needed to pay the principal, interest, taxes and other normal banking charges on the loan. Although no specific amounts are mentioned, the amounts are certain because they can be computed from the books of the National Treasury. Appropriation of public funds, public purposes. Number 7, Taai is a predominantly Muslim province. The governor, the vice-governor, and members of its Sangguniang Panlalawigan are all Muslims. Its budget provides the governor with a certain amount as his discretionary funds. Recently, however, the Sangguniang Panlalawigan passed a resolution appropriating P100,000 as a special discretionary fund of the governor, to be spent by him in leading a pilgrimage of his province mates to Mecca, Saudi Arabia, Islam's holiest city. Philconsa, on constitutional grounds, has filed suit to nullify the resolution of the Sangguniang Panlalawigan giving the special discretionary fund to the governor for the stated purpose. How would you decide the case? Give your reasons. Suggested answer. The resolution is unconstitutional. First, it violates Art. 6, Section 29 of the Constitution, which prohibits the appropriation of public money or property, directly or indirectly, for the use, benefit, or support of any system of religion, and, second, it contravenes Art. 6, SEC 25, which limits the appropriation of discretionary funds only for public purposes. The use of discretionary funds for purely religious purpose is thus unconstitutional, and the fact that the disbursement is made by resolution of a local legislative body and not by Congress does not make it any less offensive to the Constitution. Above all, the resolution constitutes a clear violation of the Non-Establishment Clause of the Constitution. Commission on Appointments. No. 3. Suppose there are 202 members in the House of Representatives. Of this number, 185 belong to the Progressive Party of the Philippines or PPP, while 17 belong to the Citizens Party or CP. How would you answer the following questions regarding the representation of the House in the Commission on Appointments? A. How many seats would the PPP be entitled to have in the Commission on Appointments? Explain your answer fully. B. Suppose 15 of the camp representatives, while maintaining their party affiliation, entered into a political alliance with the PPP in order to form the Rainbow Coalition in the House. What effect, if any, would this have on the right of the CP to have a seat or seats in the Commission on Appointments? Explain your answer fully. Suggested answer. A. The 185 members of the Progressive Party of the Philippines represent 91.58% of the 202 members of the House of Representatives. In accordance with Article 6, Section 18 of the Constitution, it is entitled to have 10 of the 12 seats in the Commission on Appointments. Although the 185 members of Progressive Party of the Philippines represent 98 seats in the Commission on Appointments, under the ruling in Gingunna v. Gonzales, 214 SCRA 789, a fractional membership cannot be rounded off to full membership because it will result in over-representation of that political party and under-representation of the other political parties. B. The political alliance formed by the 15 members of the Citizens Party with the Progressive Party of the Philippines will not result in the diminution of the number of seats in the Commission on Appointments to which the Citizens Party is entitled. As held in Cunanan v. 10. 5 SCRA 1, a temporary alliance between the members of one political party and another political party does not authorize a change in the membership of the Commission on Appointments. Otherwise, the Commission on Appointments will have to be reorganized as often as votes shift from one side to another in the House of Representatives. Delegation of powers. No. 17. Suppose that Congress passed a law creating a Department of Human Habitat and authorizing the Department Secretary to promulgate implementing rules and regulations. Suppose further that the law declared that violation of the implementing rules and regulations so issued would be punishable as a crime and authorized the Department Secretary to prescribe the penalty for such violation. If the law defines certain acts as violations of the law and makes them punishable, for example, with imprisonment of 3 years or a fine in the amount of P10,000.00, or both such imprisonment and fine, in the discretion of the court, can it be provided in the implementing rules and regulations promulgated by the Department Secretary that their violation will also be subject to the same penalties as those provided in the law itself? Explain your answer fully. Suggested answer. The rules and regulations promulgated by the Secretary of Human Habitat cannot provide that the penalties for their violation will be the same as the penalties for the violation of the law. As held in United States v. Barrias, 11 Philosophy 327. The fixing of the penalty for criminal offenses involves the exercise of legislative power and cannot be delegated. The law itself must prescribe the penalty. Delegation of powers. Section 32 of Republic Act No. 4670 reads. Seconds 32. Penal provision. A person who shall willfully interfere with, restrain or coerce any teacher in the exercise of his rights guaranteed by this act or who shall in any other manner commit any act to defeat any of the provisions of this act shall, upon conviction, be punished by a fine of not less than 100 pesos nor more than 1,000 pesos, or by imprisonment, in the discretion of the court. Is the proviso granting the court the authority to impose a penalty or imprisonment in its discretion constitutional? Explain briefly. Suggested answer. The proviso is unconstitutional. Section 32 of RA No. 4670 provides for an indeterminable period of imprisonment, with neither a minimum nor a maximum duration having been set by the legislative authority. The courts are thus given wide latitude of discretion to fix the term of imprisonment, without even the benefit of any sufficient standard, such that the duration thereof may range, in the words of respondent judge, from 1 minute to the lifespan of the accused. This cannot be allowed. It vests in the courts a power and a duty essentially legislative in nature and which, as applied to this case, does violence to the rules on separation of powers as well as the non-delegability of legislative powers. Delegation of powers, completeness test, sufficient standard test. The two accepted tests to determine whether or not there is a valid delegation of legislative power are the completeness test and the sufficient standard test. Explain each. Alternative answer. Under the completeness test, a law must be complete in all its terms and provisions when it leaves the legislature, that nothing is left to the judgment of the delegate. The legislature does not abdicate its functions when it describes what job must be done, who is to do it, and what is the scope of his authority. However, a delegation of power to make the laws which necessarily involves a discretion as to what it shall be may not constitutionally be done. Under the sufficiency of standards test, the statute must not only define a fundamental legislative policy, mark its limits and boundaries, and specify the public agency to exercise the legislative power. It must also indicate the circumstances under which the legislative command is to be effected. To avoid the taint of unlawful delegation, there must be a standard, which implies at the very least that the legislature itself determines matters of principle and lays down fundamental policy. Alternative answer. Completeness test. The law must be complete in all its essential terms and conditions when it leaves the legislature, so that there will be nothing left for the delegate to do when it reaches him except to enforce it. Sufficient standard test. A sufficient standard is intended to map out the boundaries of the delegate's authority by defining the legislative policy and indicating the circumstances under which it is to be pursued and effected. Intended to prevent a total transference of legislative power from the legislature to the delegate. The standard is usually indicated in the law delegating legislative power. Discipline, modes of removal. Number 11. How may the following be removed from office? 1. Senators and congressmen. 2. Judges of lower courts. 3. Officers and employees in the civil service. Suggested answer. 1. In accordance with Art. 3. Section 16 of the Constitution, senators and congressmen may be removed by their expulsion for disorderly behavior, with the concurrence of at least 2/3 of all the members of the House to which they belong. In addition, they may also be removed in consequence of an election contest filed with the Senate or House of Representatives Electoral Tribunal. 2. As to judges, Art. 8, SEC 11 of the Constitution. 3. As to civil service employees, Art. IXB seconds. 2 of the Constitution. Discipline, suspension of a member of the Congress. No. 2. Simeon Valera was formerly a provincial governor who ran and won as a member of the House of Representatives for the 2nd Congressional District of Iloilo. For violation of Section 3 of the Anti-Graft and Corrupt Practices Act, as amended, allegedly committed when he was still a provincial governor, a criminal complaint was filed against him before the Office of the Ombudsman, for which, upon a finding of probable cause, a criminal case was filed with the Sandiganbayan. During the course of trial, the Sandiganbayan issued an order of preventive suspension for 90 days against him. Representative Valera questioned the validity of the Sandiganbayan order on the ground that, under Article 6, Section 16 of the Constitution, he can be suspended only by the House of Representatives, and that the criminal case against him did not arise from his actuations as a member of the House of Representatives. Is Representative Valera's contention correct? Why? Suggested answer. The contention of Representative Valera is not correct as held in Santiago v. Sandiganbayan, 356 SCRA 636. The suspension contemplated in Article 6, Section 16 of the Constitution is a punishment that is imposed by the Senate or House of Representatives upon an erring member. It is distinct from the suspension under Section 13 of the Anti-Graft and Corrupt Practices Act, which is not a penalty but a preventive measure. Since Section 13 of the Anti-Graft and Corruption Practices Act does not state that the public officer must be suspended only in the office where he is alleged to have committed the acts which he has been charged, it applies to any office which he may be holding. Elected official, de facto officer. Ave ran for congressman of Chu Province. However, his opponent, Bart, was the one proclaimed and seated as the winner of the election by the Kumlik. Ave filed seasonably a protest before HRET. After 2 years, HRET reversed the Kumlik's decision and Ave was proclaimed finally as the duly elected congressman. Thus, he had only 1 year to serve in Congress. Can Ave collect salaries and allowances from the government for the first 2 years of his term as congressman? Should Bart refund to the government the salaries and allowances he had received as congressman? What will happen to the bills that Bart alone authored and were approved by the House of Representatives while he was seated as congressman? Reason and explain briefly. Suggested answer: Ave cannot collect salaries and allowances from the government for the first 2 years of his term, because in the meanwhile Bart collected the salaries and allowances. Bart was a de facto officer while he was in possession of the office. To allow Ave to collect the salaries and allowances will result in making the government pay a second time. Bart is not required to refund to the government the salaries and allowances he received. As a de facto officer, he is entitled to the salaries and allowances because he rendered services during his incumbency. Rodriguez v. Tan, 91 Philosophy 724. The bills which Bart alone authored and were approved by the House of Representatives are valid because he was a de facto officer during his incumbency. The acts of a de facto officer are valid insofar as the public is concerned. Electoral Tribunal, HRET members' right and responsibilities. No. 4. In an election case, the House of Representatives Electoral Tribunal rendered a decision upholding the election protest of Protestant A, a member of the Freedom Party, against Protest A B, a member of the Federal Party. The deciding vote in favor of A was cast by Representative X, a member of the Federal Party. For having voted against his party mate, Representative X was removed by resolution of the House of Representatives, at the instance of his party, from membership in the HRET. Representative X protested his removal on the ground that he voted on the basis of the evidence presented and contended that he had security of tenure as a HRET member and that he cannot be removed except for a valid cause. With whose contention do you agree, that of the Federal Party or that of Representative X? Why? Suggested answer: I agree with the contention of Representative X. As held in Bondoc v. Pineda, 201 SCRA 792, the members of the House of Representatives Electoral Tribunal are entitled to security of tenure like members of the judiciary. Membership in it may not be terminated except for a just cause. Disloyalty to party is not a valid ground for the expulsion of a member of the House of Representatives Electoral Tribunal. Its members must discharge their functions with impartiality and independence from the political party to which they belong. Electoral Tribunal, Senate, Jurisdiction. Number 3. Why was elected senator in the May 1987 national elections? He was born out of wedlock in 1949 of an American father and a naturalized Filipina mother. Why never elected Philippine citizenship upon reaching the age of majority? Before what body should T, the losing candidate, question the election of Y? State the reasons for your answer. Is Y a Filipino citizen? Explain your answer. Suggested answer. T. The losing candidate should question the election of Y before the Senate Electoral Tribunal, because the issue involved is the qualification of Y to be a senator. Section 17, Article 6 of the 1987 Constitution provides that the Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to the election, returns, and qualifications of their respective members. Yes, Y is a natural-born Filipino citizen. All these issues were resolved in the case of Bengzon vs. Senate Blue Ribbon Committee, 203 SCRA 767. The Supreme Court has jurisdiction over the case. Foreign Affairs, Role of House of Rep. Number 7, 5. Can the House of Representatives take active part in the conduct of foreign relations, particularly in entering into treaties and international agreements? Explain. Suggested answer. No, the House of Representatives cannot take active part in the conduct of foreign relations, particularly in entering into treaties and international agreements. As held in United States vs. Curtis Wright Export Corporation, 299 U.S. 304, the President alone is the representative of the nation in the conduct of foreign affairs. Although the Senate has the power to concur in treaties, the President alone negotiates treaties and Congress is powerless to intrude into this. However, if the matter involves a treaty or an executive agreement, the House of Representatives may pass a resolution expressing its views on the matter. Foreign Affairs, Role of Senate. Number 13, 1. Under the Constitution, what is the role of the Senate in the conduct of foreign affairs? Suggested answer. The Senate plays a role in the conduct of foreign affairs, because of the requirement in Section 21, Article 7 of the Constitution that to be valid and effective a treaty or international. Section 4, Article 18 of the Constitution provides all existing treaties or international agreements which have not been ratified shall not be renewed or extended without the concurrence of at least 2/3 of all the members of the Senate. Investigations in aid of legislation. Number 8. A case was filed before the Sandiganbayan regarding a questionable government transaction. In the course of the proceedings, newspapers linked the name of Senator J. De Leon to the scandal. Senator De Leon took the floor of the Senate to speak on a matter of personal privilege to vindicate his honor against those baseless and malicious allegations. The matter was referred to the Committee on Accountability of Public Officers, which proceeded to conduct a legislative inquiry. The committee asked Mr. Vince Ledesma, a businessman linked to the transaction and now a respondent before the Sandiganbayan, to appear and to testify before the committee. Mr. Ledesma refuses to appear and file suit before the Supreme Court to challenge the legality of the proceedings before the committee. He also asks whether the committee had the power to require him to testify, identify the issues involved and resolve them. Suggested answer. The issues involved in this case are the following. 1. Whether or not the Supreme Court has jurisdiction to entertain the case. 2. Whether or not the Committee on Accountability of Public Officers has the power to investigate a matter which is involved in a case pending in court. And 3. Whether or not the petitioner can invoke his right against self-incrimination. The Committee on Accountability of Public Officers has no power to investigate the scandal. The petitioner can invoke his right against self-incrimination, because this right is available in all proceedings. Since the petitioner is a respondent in the case pending before the Sandiganbayan, he may refuse to testify. Lawmaking, process and publication. Number 2, Ernest Cheng, a businessman, has no knowledge of legislative procedure. Cheng retains you as his legal advisor and asks enlightenment on the following matters. When does a bill become a law even without the signature of the President? When does the law take effect? provides, no law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the suggested answer. 1. Under Section 27, Article 6 of the Constitution, a bill becomes a law even without the signature of the President if he vetoed it, but his veto was overridden by 2/3 vote of all the members of both the Senate and the House of Representatives, and if the President failed to communicate his veto to the House from which the bill originated, within 30 days after the date of receipt of the bill by the President. 2. As held in Tanada vs. Tuvera, 146 SCRA 446, a law must be published as a condition for its effectivity and in accordance with Article 2 of the Civil Code. It shall take effect 15 days following the completion of its publication in the Official Gazette or in a newspaper of general circulation unless it is otherwise provided. Lawmaking, Appropriation Bill. Number 5. Are the following bills filed in Congress constitutional? A bill originating from the Senate which provides for the creation of the Public Utility Commission to regulate public service companies and appropriating the initial funds needed to establish the same. Explain. Suggested answer: a bill providing for the creation of the Public Utility Commission to regulate public service companies and appropriating funds needed to establish it may originate from the Senate. It is not an appropriation bill, because the appropriation of public funds is not the principal purpose of the bill. In Association of Small Landowners of the Philippines, Inc. vs. Secretary of Agrarian Reform 175 SCRA 343, it was held that a law is not an appropriate measure if the appropriation of public funds is not its principal purpose and the appropriation is only incidental to some other objective. Lawmaking, Appropriation Law, Automatic Renewal and Power of Augmentation. No. 11. Suppose the President submits a budget which does not contain provisions for CDF, popularly known as the pork barrel, and because of this Congress does not pass the budget. 1. Will that mean paralyzation of government operations in the next fiscal year for lack of an appropriation law? 2. Suppose in the same budget, there is a special provision in the appropriations for the armed forces authorizing the Chief of Staff, AFP, subject to the approval of the Secretary of National Defense, to use savings in the appropriations provided thereto to cover up whatever financial losses suffered by the AFP retirement and separation benefits system in the last 5 years due to alleged bad business judgment. Would you question the constitutionality validity of the special provision? Suggested answer: 1. No, the failure of Congress to pass the budget will not paralyze the operations of the government. Section 25, Article 6 of the Constitution provides, if, by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Suggested answer: 2. Yes, the provision authorizing the Chief of Staff, with the approval of the Secretary of National Defense, to use savings to cover the losses suffered by the AFP retirement and separation benefits system is unconstitutional. Section 25, 5, Article 6 of the Constitution. General Appropriation Law for their respective offices from savings and other items of their respective appropriations. In Philippine Constitution vs. Enriquez, 235 SCRA 506, 544. The Supreme Court held that a provision in the General Appropriation Act authorizing the Chief of Staff to use savings to augment the funds of the AFP retirement and separation benefits systems was unconstitutional. While Section 25 allows as an exception the realignment of savings to augment items in the General Appropriations Law for the executive branch, such right must and can be exercised only by the President pursuant to a specific law. Lawmaking, Appropriation Law, Rider Provision. No. 7. Suppose that the forthcoming General Appropriations Law for year 2002, in the portion pertaining to the Department of Education, Culture, and Sports, will contain a provision to the effect that the Reserve Officers Training Course in all colleges and universities is hereby abolished, and in lieu thereof all male college students shall be required to plant 10 trees every year for 2 years in areas to be designated by the Department of Environment and Natural Resources in coordination with the Department of Education, Culture and Sports and the local government unit concerned. It further provides that the same provision shall be incorporated in future General Appropriations Acts. There is no specific item of appropriation of funds for the purpose. Comment on the constitutionality of said provision. Suggested answer. The provision is unconstitutional, because it is a rider. Section 25, Article 6 of the Constitution provides, no provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. The abolition of the Reserve Officers Training Course involves a policy matter. As held in Philippine Constitution Association vs. Enriquez, 235 SCRA 506, this cannot be incorporated in the General Appropriations Act but must be embodied in a separate law. Lawmaking, Foreign Affairs, Treaties. Number 5, are the following bills filed in Congress constitutional? 2. A bill creating a joint legislative executive commission to give, on behalf of the Senate, its advice, consent, and concurrence to treaties entered into by the President. The bill contains the guidelines to be followed by the Commission in the discharge of its functions. Explain. Suggested answer. A bill creating a joint legislative executive commission to give, on behalf of the Senate, its advice, consent, and concurrence to treaties entered into by the President. The Senate cannot delegate this function to such a commission, because under Section 21, Article 7 of the Constitution, the concurrence of at least 2/3 of the Senate itself is required for the ratification of treaties. Lawmaking, overriding the presidential veto. Number 2, the President signs into law the Appropriations Act passed by Congress but she vetoes separate items therein, among which is a provision stating that the President may not increase an item of appropriation by transfer of savings from other items. The House of Representatives chooses not to override this veto. The Senate, however, proceeds to consider two options: to override the veto and to challenge the constitutionality of the veto before the Supreme Court. A. Is option viable? If so, what is the vote required to override the veto? B. Is option viable? If not, why not? If viable, how should the court decide the case? Suggested answer. Option 1 is not viable inasmuch as the House of Representatives, from which the Appropriations Act originated and to which the President must have returned the law, is unwilling to override the presidential veto. There is, therefore, no basis for the Senate to even consider the possibility of overriding the President's veto. Under the Constitution, the vote of 2/3 of all the members of the House of Representatives and the Senate, voting separately, will be needed to override the presidential veto. It is not feasible to question the constitutionality of the veto before the Supreme Court. In Gonzalez vs. Macarade, 191 SCRA 152, the Supreme Court upheld the constitutionality of a similar veto. Under Article 6, Sector 27 of the Constitution, a distinct and severable part of the General Appropriations Act may be the subject of a separate veto. Moreover, the vetoed provision does not relate to any particular appropriation and is more an expression of a congressional policy in respect of augmentation from savings than a budgetary provision. It is therefore an inappropriate provision and it should be treated as an item for purposes of the veto power of the President. The Supreme Court should uphold the validity of the veto in the event the question is brought before it. Lawmaking, passage of a law. Number 12, 2. A bill upon filing by a senator or a member of the House of Representatives goes through specified steps before it leaves the House of Representatives or the Senate, as the case may be. After leaving the legislature, please name the 3 methods by which said bill may become a law. Suggested answer. A bill passed by Congress may become a law in any of the following cases: if it is signed into law by the President, if it is repassed over the President's veto by the vote of 2/3 of all the members of the House of Representatives and of the Senate, if the President fails to veto it within 30 days after receipt thereof and communicate the veto to the House from which it originated. Legislative power, President Aquino's time. Number 1, Executive Orders NOS 1 and 2 issued by President Corazon C. Aquino created the Presidential Commission on Good Government and empowered it to sequester any property shown prima facie to be ill-gotten wealth of the late President Marcos, his relatives, and cronies. Executive Order Number 14 vests on the Sandiganbayan jurisdiction to try hidden wealth cases. On April 14, 1986, after an investigation, the PCGG sequestered the assets of X Corporation, Inc. X Corporation, Inc. claimed that President Aquino, as President, could not lawfully issue Executive Orders NOS 1, 2, and 14, which have the force of law, on the ground that legislation is a function of Congress. Decide. Said corporation also questioned the validity of the 3 executive orders on the ground that they are bills of attainder and, therefore, unconstitutional. Decide. Suggested answer. The contention of X Corporation should be rejected. Executive Orders NOS 1, 2, and 14 were issued in 1986. At that time President Corazon Aquino exercised legislative power. Section 1, Article 2 of the Provisional Constitution established by Proclamation No. 3, provided. Until a legislature is elected and convened under a new constitution, the President shall continue to exercise legislative power. Likewise, Section 6, Article 18 of the 1987 Constitution reads: the incumbent President shall continue to exercise legislative power until the first Congress is convened. In the case of Kapatiran ng Mga Nagalingkod sa Pamahalan ng Pilipinas, Inc. v. Tan, 163 SCRA 371. The Supreme Court ruled that the Provisional Constitution and the 1987 Constitution, both recognized the power of the President to exercise legislative powers until the first Congress created under the 1987 Constitution was convened on July 27, 1987. Executive Orders NOS 1, 2, and 14 are not bills of attainder. Legislative powers. Number 14. An existing law grants government employees the option to retire upon reaching the age of 57 years and completion of at least 30 years of total government service. As a fiscal retrenchment measure, the Office of the President later issued a memorandum circular requiring physical incapacity as an additional condition for optional retirement age of 65 years. A government employee, whose application for optional retirement was denied because he was below 65 years of age and was not physically incapacitated, filed an action in court questioning the disapproval of his application, claiming that the memorandum circular is void. Is the contention of the employee correct? Explain. Suggested answer. Yes, the contention of the employee is correct. In Marasigan vs Cruz, 150 SCRA1, it was held that such a memorandum circular is void. By introducing physical capacity as an addition for optional retirement, the memorandum circular tried to amend the law. Such a power is lodged with the legislative branch and not with the executive branch. Loans extended to members of Congress. Number 9, A. After February 2, 1987, the Philippine National Bank grants a loan to Congressman X. Is the loan violative of the Constitution? Suppose the loan had instead been granted before February 2, 1987, but was outstanding on that date with a remaining balance on the principal in the amount of P50,000. 00. Can the PNB validly give Congressman X an extension of time after said date to settle the obligation? Suggested answer. A. Whether or not the loan is violative of the 1987 Constitution depends upon its purpose. If it was obtained for a business purpose, it is violative of the Constitution. If it was obtained for some other purpose, e.g., for housing, it is not violative of the Constitution because under Section 16, Article 11, members of Congress are prohibited from obtaining loans from government-owned banks only if it is for a business purpose. If the loan was granted before the effectivity of the Constitution on February 2, 1987, the Philippine National Bank cannot extend its maturity after February 2, 1987, if the loan was obtained for a business purpose. In such a case, the extension is a financial accommodation which is also prohibited by the Constitution. Multi-party system. No. 14. Discuss the merits and demerits of the multi-party system. Suggested answer. A multi-party system provides voters with a greater choice of candidates, ideas, and platforms instead of limiting their choice to two parties, whose ideas may be sterile. It also leaves room for deserving candidates who are not acceptable to those who control the two dominant parties to seek public office. On the other hand, a multi-party system may make it difficult to obtain a stable and workable majority, since probably no party will get a majority. Likewise, the opposition will be weakened if there are several minority parties. Non-legislative powers. Number 12. Legislative powers had been vested by the Constitution in the Congress of the Philippines. In addition, the Constitution also granted the lawmaking body non-legislative powers. Kindly name 5 of the latter. Suggested answer. Congress has the following non-legislative powers: to decide whether the President is temporarily disabled in the event he reassumes his office after the Cabinet, by a majority of vote of its members, declared that he is unable to discharge the powers and duties of his office and now within 5 days insists that the President is really unable to discharge the powers and duties of the Presidency, to concur in the grant of amnesty by the President, to initiate through the House of Representatives and, through the Senate, to try all cases of impeachment against the President, Vice President, the members of the Supreme Court, the members of the Constitutional Commissions and the Ombudsman. For culpable violation of the Constitution, treason, bribery, graft, and corruption, other high crimes, or betrayal of public trust. Art. 11, SECS. 2-3. To act as a constituent assembly for the revision or amendment of the Constitution. Art. 17. Non-legislative powers, emergency powers, requisites. Number 11. During a period of national emergency, Congress may grant emergency powers to the President, state the conditions under which such vesture is allowed. Suggested answer. Under Section 23, Article 6 of the Constitution, Congress may grant the President emergency powers subject to the following conditions. There is a war or other national emergency. The grant of emergency powers must be for a limited period. The grant of emergency powers is subject to such restrictions as Congress may prescribe, and the emergency powers must be exercised to carry out a declared national policy. Prohibitions and inhibitions of public office. Jar faces a dilemma: should he accept a cabinet appointment now or run later for senator? Having succeeded in law practice as well as prospered in private business where he and his wife have substantial investments, he now contemplates public service but without losing the flexibility to engage in corporate affairs or participate in professional activities within ethical bounds. Taking into account the prohibitions and inhibitions of public office whether as senator or secretary, he turns to you for advice to resolve his dilemma. What is your advice? Explain briefly. Suggested answer: I shall advise Jar to run for senator. As a senator, he can retain his investments in his business, although he must make a full disclosure of his business and financial interests and notify the Senate of a potential conflict of interest if he authors a bill. He can continue practicing law, but he cannot personally appear as counsel before any court of justice, the electoral tribunals, or quasi-judicial and other administrative bodies. As a member of the cabinet, Jar cannot directly or indirectly practice law or participate in any business. He will have to divest himself of his investments in his business. In fact, the constitutional prohibition imposed on members of the cabinet covers both public and private office or employment. Civil Liberties Union v. Executive Secretary, 194 SCRA 317. Qualifications: Congressman. Number 13, Robert Brown was born in Hawaii on May 15, 1962, of an American father and a Filipina mother. On May 16, 1983, while holding an American passport, he registered as a Filipino with the Philippine Consulate at Honolulu, Hawaii. In September 1983 he returned to the Philippines, and took up residence at BOAC, Marinduque, hometown of his mother. He registered as a voter, voted, and even participated as a leader of one of the candidates in that district in the 1984 Batison elections. In the elections of 1987, he ran for congressman, and won. His sole opponent is now questioning his qualifications and is trying to oust him on two basic claims: he is not a natural-born Filipino citizen, but is in fact an American, born in Hawaii, an integral portion of the USA, who holds an American passport. He did not meet the age requirement, and he has a green card from the US government. Assume that you are a member of the House Electoral Tribunal where the petition for Brown's ouster is pending. How would you decide the three issues raised against him? Suggested answer: the first and third grounds have no merit, but the second is well taken and, therefore, Brown should be disqualified. 1. Robert Brown is a natural-born citizen of the Philippines. A person born of a Filipino mother and an alien father before January 17, 1973, who thereafter upon reaching the age of majority elect Philippine citizenship, is a citizen of the Philippines. Art. 4. SEC 1. Under Art. 4. SEC 2 he is also deemed a natural-born citizen. 2. The Constitution requires, among other things, that a candidate for member of the House of Representatives must be at least 25 years of age on the day of the election. As Brown was born on May 15, 1962, he did not become 25 years old until May 15, 1987. Hence on May 11, 1987, when the election was held, he was 4 days short of the required age. 3. The Constitution provides that those who seek either to change their citizenship or to acquire the status of an immigrant of another country during their tenure shall be dealt with by law. The provision cannot apply to Brown for the following reasons. First, Brown is in addition an American citizen and thus has a dual citizenship which is allowed by the Constitution. Cf. Art. 4, Section 4. Second, Brown did not seek to acquire the status of an immigrant, but is an American by birth under the principle of jus soli obtaining in the United States. Third, he did not seek to change his status during his tenure as a public officer. Fourth, the provision of Art. 11, Section 17 is not self-executing but requires an implementing law. Fifth, but above all, the House Electoral Tribunal has no jurisdiction to decide this question since it does not concern the qualification of a member-elect. Qualifications: Congressman. Number 1, in 1964. Rufa, a Filipina domestic helper working in Hong Kong, went to Taipei for a vacation, where she met Cheng Xiaopao, whom she married. Under Chinese law, Rufa automatically became a Chinese citizen. The couple resided in Hong Kong, where on May 9, 1965, Rufa gave birth to a boy named Ernest. Upon reaching the age of majority, Ernest elected Philippine citizenship. After the EDSA revolution, Ernest decided to live permanently in the Philippines, where he prospered as a businessman. During the May 11, 1993 election, Ernest ran and won as a congressman. His opponent, noting Ernest's Chinese ancestry, filed a petition to disqualify the latter on the following grounds: Ernest Cheng is not a natural-born Filipino, and he is underaged. Decide. Suggested answer. 1. Ernest cannot be disqualified. 2. Ernest is not underaged. Having been born on May 9, 1965, he was over 25 years old on the date of the May 11, 1993 election. Section 6, Article 6 of the Constitution, requires congressmen to be at least 25 years of age on the day of the election. Qualifications: Congressman. No. 3. C. Victor Ahmed was born on December 16, 1972 of a Filipino mother and an alien father. Under the law of his father's country, his mother did not acquire his father's citizenship. Victor consults you on December 21, 1993 and informs you of his intention to run for Congress in the 1995 elections. Is he qualified to run? What advice would you give him? Would your answer be the same if he had seen and consulted you on December 16, 1991 and informed you of his desire to run for Congress in the 1992 elections? Discuss your answer. First alternative answer. C. No, Victor Ahmed is not qualified to run for Congress in the 1995 elections. Under Section 6, Article 6 of the Constitution, a member of the House of Representatives must be at least 25 years of age on the day of the election. Since he will be less than 25 years of age in 1995, Victor Ahmed is not qualified to run. Under Section 2, Article 4 of the Constitution, to be deemed a natural-born citizen, Victor Ahmed must elect Philippine citizenship upon reaching the age of majority. I shall advise him to elect Philippine citizenship, if he has not yet done so, and to wait until the 1998 elections. My answer will be the same if he consulted me in 1991 and informed me of his desire to run in the 1992 elections. Second alternative answer. C. Under Section 2, Article 4 of the Constitution, Victor Ahmed must have elected Philippine citizenship upon reaching the age of majority to be considered a natural-born citizen and qualified to run for Congress. Republic Act No. 6809 reduced the majority age to 18 years. Kienko v. Secretary of Justice, 5 SCRA 108 recognized 3 years from reaching the age of majority as the reasonable period for electing Philippine citizenship. Since Republic Act No. 6809 took effect in 1989 and there is no showing that Victor Ahmed elected Philippine citizenship within 3 years from the time he reached the age of majority on December 16, 199C, he is not qualified to run for Congress. If he consulted me on December 16, 1991, I would inform him that he should elect Philippine citizenship so that he can be considered a natural-born citizen. Separation of powers. Number 25. Can any other department or agency of the government review a decision of the Supreme Court? Why or why not? Suggested answer. No. The Supreme Court is the highest arbiter of legal questions. Javier v. Kumlik, 144 SCRA 194. To allow review of its decision by the other departments of government would upset the classic pattern of separation of powers and destroy the balance between the judiciary and the other departments of government. As the justices said in their answer to the complaint for impeachment in the Committee on Justice of the House of Representatives, just as it is completely unacceptable to file charges against the individual members of Congress for the laws enacted by them upon the argument that these laws are violative of the Constitution, or are a betrayal of public trust, or are unjust, so too, should it be equally impermissible to make the individual members of the Supreme Court accountable for the Court's decisions or rulings. Separation of powers. No. 2. A group of losing litigants in a case decided by the Supreme Court filed a complaint before the Ombudsman charging the justices with knowingly and deliberately rendering an unjust decision in utter violation of the penal laws of the land. Can the Ombudsman validly take cognizance of the case? Explain. Suggested answer. No, the Ombudsman cannot entertain the complaint. As stated in the case of Enri, Lorta. 148 SCRA 382, pursuant to the principle of separation of powers, the correctness of the decisions of the Supreme Court as final arbiter of all justiciable disputes is conclusive upon all other departments of the government. The Ombudsman has no power to review the decisions of the Supreme Court by entertaining a complaint against the justices of the Supreme Court for knowingly rendering an unjust decision. Second alternative answer. Article 11. Section 1 of the 1987 Constitution provides that public officers must at all times be accountable to the people. Section 22 of the Ombudsman Act provides that the Office of the Ombudsman has the power to investigate any serious misconduct allegedly committed by officials removable by impeachment for the purpose of filing a verified complaint for impeachment if warranted. The Ombudsman can entertain the complaint for this purpose. 3-term limit, Congressman. Number 13, X, a member of the House of Representatives, was serving his third consecutive term in the House. In June 1996 he was appointed Secretary of National Defense. Can he run for election to the Senate in the 1998 elections? Explain. Suggested answer. Yes, X can run for the Senate in the 1988 election. Under Section 7, Article X of the Constitution, having served for 3 consecutive terms as member of the House of Representatives, X is only prohibited from running for the same position. 3-term limit, Congressman. No. V, during his third term, A member of the House of Representatives, was suspended from office for a period of 60 days by his colleagues upon a vote of 2/3 of all the members of the House. In the next succeeding election, he filed his certificate of candidacy for the same position. B. The opposing candidate filed an action for disqualification of A on the ground that the latter's candidacy violated Section 7. Article 6 of the Constitution, which provides that no member of the House of Representatives shall serve for more than 3 consecutive terms. A. Answered that he was not barred from running again for that position because his service was interrupted by his 6-0 day suspension, which was involuntary. Can A. legally continue with his candidacy, or is he already barred? Why? Suggested answer. A cannot legally continue with his candidacy. He was elected as member of the House of Representatives for a third term. This term should be included in the computation of the term limits, even if A did not serve for a full term. He remained a member of the House of Representatives even if he was suspended. Article AEI Executive Department Appointing Power, Acting vs. Permanent Appointment. No v. What is the nature of an acting appointment to a government office? Does such an appointment give the appointee the right to claim that the appointment will, in time, ripen into a permanent one? Explain. Suggested answer. According to Sevilla v. Court of Appeals 209 SCRA 637, an acting appointment is merely temporary. As held in Murahamzar v. Alonto 194 SCRA 390, a temporary appointment cannot become a permanent appointment, unless a new appointment which is permanent is made. This holds true unless the acting appointment was made because of a temporary vacancy. In such a case, the temporary appointee holds office until the assumption of office by the permanent appointee. Appointing power, ad interim appointments. Number 3, on May 3, 1992, while Congress is on a short recess for the elections, the President appoints Renato da Silva to the rank of General in the Armed Forces. She also designates him as Chief of Staff of the AFP. He immediately takes his oath and assumes that office, with the rank of 4-star General of the AFP. When Congress resumes its session on May 17, 1992, the Commission on Appointments informs the Office of the President that it has received from her office only the appointment of Da Silva to the rank of 4-star General, and that unless his appointment to the office of the Chief of Staff of the AFP is also submitted, the Commission will not act on the matter. The President maintains that she has submitted to the Commission all that the Constitution calls for. Who is correct? Did Jen Da Silva violate the Constitution in immediately assuming office prior to a confirmation of his appointment? Are the appointment and designation valid? Suggested answer. The President is correct. Under Presidential Decree No. 360, the grade of 4-star General is conferred only upon the Chief of Staff. Hence, the appointment of Renato da Silva as a 4-star General must be deemed to carry with it his appointment as Chief of Staff of the AFP. Gen. Renato da Silva did not violate the Constitution when he immediately assumed office before the confirmation of his appointment, since his appointment was an ad interim appointment. Under Article 6I, Sector 16 of the Constitution, such appointment is immediately effective and is subject only to disapproval by the Commission on Appointments or as a result of the next adjournment of the Congress. The appointment and designation of Jen Da Silva are valid for reasons given above. However, From another point of view, they are not valid because they were made within the period of the ban for making appointments. Under Article 7, Seconds 15, the President is prohibited from making appointments within the period of 2 months preceding the election for President and Vice President. The appointment in this case will be made on May 3, 1992, which is just 8 days away from the election for President and Vice President on May 11, 1992. For this reason, the appointment and designation of Jen De Silva are after all invalid. Appointing power, ad interim appointments. Number 16, in December 1988, while Congress was in recess, A was extended an ad interim appointment as Brigadier General of the Philippine Army, in February 1989. When Congress was in session, B was nominated as Brigadier General of the Philippine Army. B's nomination was confirmed on August 5, 1989, while A's appointment was confirmed on September 5, 1989. Who is deemed more senior of the two, A or B? Suppose Congress adjourned without the Commission on Appointments acting on both appointments, can A and B retain their original ranks of colonel? Suggested answer. 1. A is senior to B. In accordance with the ruling in Summers vs. Ozeta. 81 Philosophy 754, the ad interim appointment extended to A is permanent and is effective upon his acceptance, although it is subject to confirmation by the Commission on Appointments. 2. If Congress adjourned without the appointments of A and B having been confirmed by the Commission on Appointments, A cannot return to his old position. As held in Summers vs. Xita, 81 Philosophy 754, by accepting an ad interim appointment to a new position, A waived his right to hold his old position. On the other hand, since B did not assume the new position, he retained his old position. Appointing power, appointments requiring confirmation, RA 6975 unconstitutional. Novi, on December 13, 1990, the President signed into law Republic Act No. 6975, creating the Department of Interior and Local Government. Sections 26 and 31 of the law provide that senior officers of the Philippine National Police, from Senior Superintendent, Chief Superintendent, Deputy Director General to Director General or Chief of PNP shall, among others, be appointed by the President subject to confirmation by the Commission on Appointments. In 1991, the President promoted Chief Superintendent Roberto Matapang and Senior Superintendent Conrado Mahigpit to the positions of Director and Chief Superintendent of the PNP, respectively. Their appointments were in a permanent capacity. Without undergoing confirmation by the Commission on Appointments, Matapang and Mahigpit took their oath of office and assumed their respective positions. Thereafter, the Department of Budget and Management authorized disbursements for their salaries and other emoluments. Juan Bantay filed a taxpayers' suit questioning the legality of the appointments and disbursements made. Bantay argues that the appointments are invalid inasmuch as the same have not been confirmed by the Commission on Appointments, as required under Sections 26 and 31 of RA No. 6975. Determine with reasons the legality of the appointments and the disbursements for salaries by discussing the constitutional validity of Sections 26 and 31 of RA No. 6975. Suggested answer. The appointments of Matapang and Mahigpit are valid even if they were not confirmed by the Commission on Appointments. Because they are not among the public officials whose appointments are required to be confirmed by the first sentence of Article 7, Section 16 of the Constitution. According to Manalo v. Sistaza, 312 SCRA 239. Sections 26 and 31 of Republic Act 6975 are unconstitutional, because Congress cannot by law expand the list of public officials required to be confirmed by the Commission on Appointments. Since the appointments of Matapang and Mahigpit are valid, the disbursements of their salaries and emoluments are valid. Appointing power, categories of officials. A1. What are the 6 categories of officials who are subject to the appointing power of the President? 2. Name the category or categories of officials whose appointments need confirmation by the Commission on Appointments. Suggested answer. Under Section 16, Article 7 of the Constitution, the 6 categories of officials who are subject to the appointing power of the President are the following. 1. HEAD of Executive Departments, 2 Ambassadors. Other public ministers and consuls, 3 officers of the armed forces from the rank of colonel or naval captain, 4 OTHER officers whose appointments are vested in him by the Constitution. 5 ALL other officers of the government whose appointments are not otherwise provided by law, and 6 THOSE whom he may be authorized by law to appoint. 2. According to Sarmiento v. Mizon, 156 SCRA 549, the only officers whose appointments need ambassadors, other public ministers and consuls, officers of the armed forces from the rank of colonel or naval captain, and other officials whose appointments are vested in the President by the Constitution. Appointing power, kinds of appointments. When is an appointment in the civil service permanent? Distinguish between an appointment in an acting capacity extended by a department secretary from an ad interim appointment extended by the President. Distinguish between a provisional and a temporary appointment. Suggested answer. 1. Under Section 25 of the Civil Service Decree, an appointment in the civil service is permanent when issued to a person who meets all the requirements for the position to which he is being appointed, including the appropriate eligibility prescribed, in accordance with the provisions of law, rules, and standards promulgated in pursuance thereof. 2. An appointment in an acting capacity extended by a department secretary is not permanent but temporary. Hence, the department secretary may terminate the services of the appointee at any time. On the other hand, an AD interim appointment extended by the President is an appointment which is subject to confirmation by the Commission on Appointments and was made during the recess of Congress. As held in Summers v. Esqueda, 81 Philosophy 754, an ad interim appointment is permanent. 3. In Section 24 of the Civil Service Act of 1959, a temporary appointment is one issued to a person to a position needed only for a limited period not exceeding 6 months. Under Section 25 of the Civil Service Decree, a temporary appointment is one issued to a person who meets all the requirements for the position to which he is being appointed except the appropriate civil service eligibility because of the absence of appropriate eligibles and it is necessary in the public interest to fill the vacancy. On the other hand, Section 24 of the Civil Service Act of 1959 defined a provisional appointment as one issued upon the prior authorization of the Civil Service Commission in accordance with its provisions and the rules and standards promulgated in pursuance thereto to a person who has not qualified in an appropriate examination but who otherwise meets the requirements for appointment to a regular position in the competitive service. Whenever a vacancy occurs and the filling thereof is necessary in the interest of the service and there is no appropriate register of eligibles at the time of appointment. Provisional appointments in general have already been abolished by Republic Act 6040. However, it still applies with regard to teachers under the Magna Carta for public school teachers. Alternative answer. The case of Regis vs. Osmina, 197 SCRA 308, laid down the distinction between a provisional and a temporary appointment. A provisional appointment is extended to a person who has not qualified in an appropriate examination but who otherwise meets the requirements for appointment to a regular position in the competitive service whenever a vacancy occurs and they Filling thereof is necessary in the interest of the service and there is no appropriate register of eligible at the time of the appointment. On the other hand, a temporary appointment given to a non-civil service eligible is without a definite tenure and is dependent on the pleasure of the appointing power. A provisional appointment is good only until replacement by a civil service eligible and in no case beyond 30 days from date of receipt by the appointing officer of the certificate of eligibility. A provisional appointment contemplates a different situation from that of a temporary appointment. Whereas a temporary appointment is designed to fill a position needed only for a limited period not exceeding 6 months, a provisional appointment, on the other hand, is intended for the contingency that a vacancy occurs and the filling thereof is necessary in the interest of the service and there is no appropriate register of eligibles at the time of the appointment. In other words, the reason for extending a provisional appointment is not because there is an occasional work to be done and is expected to be finished in not more than 6 months, but because the interest of the service requires that certain work be done by a regular employee, only that no one with appropriate eligibility can be appointed to it. Hence, any other eligible may be appointed to do such work in the meantime that a suitable eligible does not qualify for the position. To be more precise, a provisional appointment may be extended only to a person who has not qualified in an appropriate examination but who otherwise meets the requirements for appointment to a regular position in the competitive service, meaning one who must anyway be a civil service eligible. In the case of a temporary appointment, all that the law enjoins is that preference in filling such position be given to persons on appropriate eligible lists. Merely giving preference presupposes that even a non-eligible may be appointed. Under the law, even if the appointee has the required civil service eligibility, his appointment is still temporary simply because such is the nature of the work to be done. Note, since provisional appointments have already been abolished, examinees should be given full credit for whatever answer they may or may not give. Appointing power, limitations on presidential appointments. Number 7, a month before a forthcoming election, A. One of the incumbent commissioners of the Cumlic died while in office and B. Another commissioner suffered a severe stroke. In view of the proximity of the elections and to avoid paralyzation in the Cumlic, the president, who was not running for any office, appointed Commissioner C of the Commission on Audit, who was not a lawyer but a certified public accountant by profession, ad interim commissioner to succeed Commissioner A and designated by way of a temporary measure Associate Justice D of the Court of Appeals as acting Associate Commissioner during the absence of Commissioner B. Did the President do the right thing in extending such ad interim appointment in favor of Commissioner C and designating Justice D acting Commissioner of the Cumlic? Suggested answer: no. The President was wrong in extending an ad interim appointment in favor of Commissioner C. In Summers vs. Sozeta, 81 Philosophy 754, it was held that an ad interim appointment is a permanent appointment. Under Section 15, Article 7 of the Constitution, within 2 months immediately before the next presidential elections and up to the end of his term, the President cannot make permanent appointments. The designation of Justice D as acting Associate Commissioner is also invalid. Section 1. Article IXC of the Constitution prohibits the designation of any commissioner of the Cumlic in a temporary or acting capacity. Section 12, Article 8 of the Constitution prohibits the designation of any member of the judiciary to any agency performing quasi-judicial or administrative functions. Appointing powers, ad interim appointments. In March 2001, while Congress was adjourned, the president appointed Santos as chairman of the Cumlic. Santos immediately took his oath and assumed office. While his appointment was promptly submitted to the Commission on Appointments for confirmation, it was not acted upon and Congress again adjourned. In June 2001, the President extended a second ad interim appointment to Santos for the same position with the same term, and this appointment was again submitted to the Commission on Appointments for confirmation. Santos took his oath anew and performed the functions of his office. Reyes, a political rival, filed a suit assailing certain orders issued by Santos. He also questioned the validity of Santos' appointment. Resolve the following issues. Does Santos' assumption of office on the basis of the ad interim appointments issued by the President amount to a temporary appointment which is prohibited by Section 1, Article IXC of the Constitution? Alternative answer. No, Santos' appointment does not amount to a temporary appointment. An ad interim appointment is a permanent appointment because it takes effect immediately and can no longer be withdrawn by the President once the appointee has qualified into office. The fact that it is subject to confirmation by the Commission on Appointments does not alter its permanent character. The Constitution itself makes an ad interim appointment permanent in character by making it effective until disapproved by the Commission on Appointments or until the next adjournment of Congress. A temporary or acting appointee does not enjoy any security of tenure, no matter how briefly. Madibag v. Benapeo, Gr. Number 149036, April 2, 2002. Alternative answer. An ad interim appointment is a permanent appointment and does not violate Section 1, Article IXC of the Constitution. Assuming the legality of the first ad interim appointment and assumption of office by Santos, were his second ad interim appointment and subsequent assumption of office to the same position violations of the prohibition on reappointment under Section 1, Article IXC of the Constitution? Suggested answer. No, the second ad interim appointment and subsequent assumption of office does not violate the Constitution. The prohibition on reappointment in Section 1, Article IXC of the Constitution does not apply to bypassed ad interim appointments. It can be revived by a new ad interim appointment because there is no final disapproval under Section 16, Article 7 of the Constitution, and such new appointment will not result in the appointee serving beyond the fixed term of 7 years. The phrase "without reappointment" applies only to one who has been appointed by the President and confirmed by the Commission on Appointments, whether or not such person completes his term of office. To hold otherwise will lead to absurdities and negate the President's power to make ad interim appointments. Madibag v. Benapeo, Gr. No. 149036, April 2, 2002. Cabinet members, limitation on accepting additional duties. 1996 Number 7, can the Secretary of Finance be elected Chairman of the Board of Directors of the San Miguel Corporation? Explain. Suggested answer. No, the Secretary of Finance cannot be elected Chairman of the Board of Directors of the San Miguel Corporation. Under Section 13, Article 7 of the Constitution, members of the Cabinet cannot hold any other office or employment during their tenure unless it is otherwise provided in the Constitution. They shall not also during said tenure participate in any business or be financially interested in any contract with, or in any franchise, or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. Calling out power, President. 1. What do you mean by the calling out power of the President under Section 18, Article 7 of the Constitution? Suggested answer. Under Article 7, Seconds 18 of the 1987 Constitution, whenever it becomes necessary, the President, as Commander-in-Chief, may call out the armed forces to aid him in preventing or suppressing lawless violence, invasion, or rebellion. David V. Arroyo, GR number 171396, May 3, 2006. Declaration, State of Calamity, Legal Effects. To give the much-needed help to the province of Aurora, which was devastated by typhoons and torrential rains, the President declared it in a state of calamity. Give at least 4 legal effects of such declaration. Suggested answer. Declaration of a state of calamity produces, inter alia, these legal effects within the province of Aurora. 1. Automatic price control under RA. Number 7581, the Price Act. 2. Authorization for the importation of rice under R. A. Number 8178, the Agricultural Tariffication Act. 3. Automatic appropriation under RA No. 7160 is available for unforeseen expenditures arising from the occurrence of calamities in areas declared to be in a state of calamity. 4. Local government units may enact a supplemental budget for supplies and materials or payment of services to prevent danger to or loss of life or property, under RA number 7160. 5. Entitlement to hazard allowance for public health workers, under RA number 7305, Magna Carta for public health workers, who shall be compensated hazard allowances equivalent to at least 25% of the monthly basic salary of health workers receiving salary grade 19 and below, and 5% for health workers with salary grade 20 and above. 6. Entitlement to hazard allowance for science and technological personnel of the government under RA number 8439, and 7. A crime committed during the state of calamity will be considered aggravated under Art. 14, PAR 7 of the Revised Penal Code. Declaration, State of National Emergency. 2. On February 24, 2006, President Gloria Macapagal Arroyo issued Proclamation No. 1017 declaring a state of national emergency. Is this proclamation constitutional? Explain. Suggested answer. The proclamation is constitutional insofar as it constitutes a call by the President for the AFP to prevent or suppress lawless violence, as this is sustained by Section 18, Article 7 of the Constitution. However, PP 1017's provisions giving the President express or implied power to issue decrees to direct the AFP to enforce obedience to all laws, even those not related to lawless violence, as well as decrees promulgated by the President, and to impose standards on media or any form of prior restraint on the press, are ultra vires and unconstitutional. Likewise, under Section 17, Article 12 of the Constitution, the President, in the absence of legislation, cannot take over privately owned public utilities and businesses affected with the public interest. David V. Arroyo, GR number 171396, May 3, 2006. 3. During the effectivity of this proclamation, Jenner, Leto, and Bong were arrested by the police for acts of terrorism. Is the arrest legal? Explain. Suggested answer. The arrest, apparently done without a valid warrant, is illegal. However, a warrantless arrest would be valid if those accused are caught committing crimes and flagranti delicto. On the other hand, if the arrest is made pursuant to a valid warrant, then it is lawful. The term acts of terrorism has not been legally defined and made punishable by Congress. No law has been enacted to guide the law enforcement agents, and eventually the courts, to determine the limits in making arrests for the commission of said acts of terrorism. Enter into contract or guarantee foreign loans. Number 13. The President of the Philippines authorized the Secretary of Public Works and Highways to negotiate and sign a loan agreement with the German government for the construction of a dam. The Senate, by a resolution, asked that the agreement be submitted to it for ratification. The Secretary of Foreign Affairs advised the Secretary of Public Works and Highways not to comply with the request of the Senate. 2. Is the President bound to submit the agreement to the Senate for ratification? Suggested answer: no, the President is not bound to submit the agreement to the Senate for ratification. Under Section 20, Article 7 of the Constitution, only the prior concurrence of the Monetary Board is required for the President to contract foreign loans on behalf of the Republic of the Philippines. Enter into contract or guarantee foreign loans. No. What are the restrictions prescribed by the Constitution on the power of the President to contract or guarantee foreign loans on behalf of the Republic of the Philippines? Explain. Suggested answer: under Section 20, Article 7 of the Constitution, the power of the President to contract or guarantee loans on behalf of the Republic of the Philippines is subject to the prior concurrence of the Monetary Board and subject to such limitations as may be prescribed by law. Enter into executive agreements. No. XX. An executive agreement was executed between the Philippines and a neighboring state. The Senate of the Philippines took it upon itself to procure a certified true copy of the executive agreement and, after deliberating on it, declared, by a unanimous vote, that the agreement was both unwise and against the best interest of the country. Is the executive agreement binding? From the standpoint of Philippine law and from the standpoint of international law? Explain. Suggested answer: from the standpoint of Philippine law, the executive agreement is binding. According to Commissioner of Customs v. Eastern Sea Trading 3 SCRA 351, the President can enter into an executive agreement without the necessity of concurrence by the Senate. The executive agreement is also binding from the standpoint of international law. Impose tariff rates, import and export quotas. No. What are the limitations/restrictions provided by the Constitution on the power of Congress to authorize the President to fix tariff rates, import and export quotas, tonnage and wharfage dues? Explain. Suggested answer: according to Section 28, Article 6 of the Constitution, Congress may, by law, authorize the President to fix within specified limits, and subject to such limitations and restrictions it may impose, tariff rates, import and export quotas, tonnage and wharfage dues and other duties or imposts within the framework of the National Development Program of the government. Martial law and suspension of writ of habeas corpus. No. 17. One of the features of the government established under the 1987 Constitution is the restoration of the principle of checks and balances. This is especially noteworthy in the Commander-in-Chief powers of the President, which substantially affects what was styled under the past dispensation as the calibrated response to national emergencies. Discuss fully the provisions of the 1987 Constitution, giving the scope, limits, and the role of the principle of checks and balances on the President's exercise of the power. P. To suspend the privilege of the writ of habeas corpus. See Proclamation of Martial Law. Considering the pressing problems of insurgency, rebel activities, liberation movements, and terrorist violence, which in your considered opinion among the options available to the President as Commander-in-Chief would be the most effective in meeting the emergencies by the nation? Explain. Suggested answer: the President's power to suspend the privilege of the writ of habeas corpus and to proclaim martial law is subject to several checks by Congress and by the Supreme Court. The President is required to report to Congress within 48 hours his action in declaring martial law or suspending the privilege of the writ, and Congress is in turn required to convene, if it is not in session, within 24 hours following the proclamation of martial law or the suspension of the privilege without need of any call, in accordance with its rules. The proclamation of martial law or suspension of the writ is effective for 60 days only, but Congress can cut short its effectivity by revoking the proclamation by the vote of at least a majority of all its members, voting jointly. Any extension of the proclamation of martial law or suspension of the writ can only be granted by Congress, which will determine also the period of such extension. On the other hand, the Supreme Court exercises a check on executive action in the form of judicial review at the instance of any citizen. The Constitution embodies in this respect the ruling in Garcia v. Lansing 42 SCRA 448 that the court can determine the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege or the extension thereof, not for the purpose of supplanting the judgment of the President but to determine whether the latter did not act arbitrarily. Indeed, Art. 8. Sector 1 imposes upon the courts the duty of determining whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the other branches of the government, in this case, the President. The President cannot, by means of the proclamation of martial law, suspend the Constitution or supplant the courts and the legislature. Neither can he authorize the trial of civilians by military tribunals so long as courts are open and functioning, thus overruling the case of Aquino v. Military Commission No. 2, 63 SCRA 546. His proclamation of martial law does not carry with it the suspension of the writ of habeas corpus, so that the decision on Aquino v. Ponce Enrile, 59 SCRA 183 is now overruled. Nor does the suspension of the writ deprive courts of their power to admit persons to bail, where proper. The Constitution thus overrules the cases of Garcia Padilla v. Ponce Enrile, 121 SCRA 472 and Morales v. Ponce Enrile, 121 SCRA 538. The President has three options: to call out the armed forces to prevent or suppress lawless violence, invasion, or rebellion, to suspend the privilege of the writ of habeas corpus, or to proclaim martial law. The last two options can be resorted to only in cases of invasion or rebellion, when public safety requires either the suspension of the privilege or the proclamation of martial law. It is submitted that the most effective means of meeting the current emergency, which is brought about by rebellion, liberation movements, and terrorism, is to simply call out the armed forces for the following reasons. 1. The exigencies to be met are not solely those caused by invasion or rebellion but terrorism and other crimes. 2. Suspension of the privilege will only be for a limited period, and then the period of retention is limited to 3 days, which may not really be effective. On the other hand, public criticism of the action may only erode the President's authority. 3. There is practically little difference, as far as the ability of the President to meet an emergency is concerned, between option 1, on the other hand, the options 2 and 3. The President may well take comfort in the following thought: government of limited power need not be anemic government. Assurance that rights are secure tends to diminish fear and jealousy of strong government, and, by making us feel safe to live under it, makes for its better support. West vs. State BRD of EDUCV. Barnett, 319 U.S. 624. Martial law, limitations. No. 17. Declaring a rebellion, hostile groups have opened and maintained armed conflicts on the islands of Sulu and Basilan. A. To quell this, can the President place under martial law the islands of Sulu and Basilan? Give your reasons. B. What are the constitutional safeguards on the exercise of the President's power to proclaim martial law? Suggested answer. A. If public safety requires it, the President can place Sulu and Basilan under martial law since there is an actual rebellion. Under Section 18, Article 7 of the Constitution, the President can place any part of the Philippines under martial law in case of rebellion, when public safety requires it. B. The following are the constitutional safeguards on the exercise of the power of the President to proclaim martial law. A. There must be actual invasion or rebellion. B. The duration of the proclamation shall not exceed 60 days. C. Within 48 hours, the President shall report his action to Congress. If Congress is not in session, it must convene within 24 hours. D. Congress may by majority vote of all its members voting jointly revoke the proclamation, and the President cannot set aside the revocation. E. By the same vote and in the same manner, upon initiative of the President, Congress may extend the proclamation if the invasion or rebellion continues and public safety requires the extension. F. The Supreme Court may review the factual sufficiency of the proclamation, and the Supreme Court must decide the case within 30 days from the time it was filed. G. Martial law does not automatically suspend the privilege of the writ of habeas corpus or the operation of the Constitution. H. It does not supplant the functioning of the civil courts and of Congress. Military courts have no jurisdiction over civilians where civil courts are able to function. Martial law, sufficiency of the factual basis. The President issued a proclamation number 1018 placing the Philippines under martial law on the ground that a rebellion staged by lawless elements is endangering the public safety. Pursuant to the proclamation, suspected rebels were arrested and detained and military tribunals were set up to try them. Robert Dela Cruz, a citizen, filed with the Supreme Court a petition questioning the validity of Proclamation number 1018. 1. Does Robert have a standing to challenge Proclamation number 1018? Explain. Suggested answer: yes, Robert has standing. Under Article 8, Section 17 of the 1987 Constitution, the Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law. As citizen therefore, Robert may file the petition questioning Proclamation number 1018. 2. In the same suit, the Solicitor General contends that under the Constitution, the President as Commander-in-Chief determines whether the exigency has arisen requiring the exercise of his power to declare martial law and that his determination is conclusive upon the courts. How should the Supreme Court rule? Suggested answer: the Supreme Court should rule that his determination is not conclusive upon the courts. The 1987 Constitution allows a citizen, in an appropriate proceeding, to file a petition questioning the sufficiency of the factual basis of said proclamation. Moreover, the power to suspend the privilege of the writ of habeas corpus and the power to impose martial law involve the curtailment and suppression of certain basic civil rights and individual freedoms, and thus necessitate safeguards by Congress and review by the Supreme Court. IBP v. Zamora, Gr. No. 141284, August 15, 2000. 3. The Solicitor General argues that, in any event, the determination of whether the rebellion poses danger to public safety involves a question of fact and the Supreme Court is not a trier of facts. What should be the ruling of the court? 2. 5%. Suggested answer: judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Art. Venn, Sector 1, PAR 2, 1987 Constitution. When the grant of power is qualified, conditional or subject to limitations, the issue of whether the prescribed qualifications or conditions have been met or the limitations respected, is justiciable, the problem being one of legality or validity, not its wisdom. Article 7, Section 18 of the 1987 Constitution specifically grants the Supreme Court the power to review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law. Thus, in the matter of such declaration, two conditions must concur: there must be an actual invasion or rebellion, and public safety must require it. The Supreme Court cannot renege on its constitutional duty to determine whether or not the said factual conditions exist. 4. Finally, the Solicitor General maintains that the President reported to Congress such proclamation of martial law, but Congress did not revoke the proclamation. What is the effect of the inaction of Congress on the suit brought by Robert to the Supreme Court? Suggested answer. The inaction of Congress has no effect on the suit brought by Robert to the Supreme Court, as Article 8, Section 18 provides for checks on the President's power to declare martial law to be exercised separately by Congress and the Supreme Court. Under said provision, the duration of martial law shall not exceed 60 days, but Congress has the power to revoke the proclamation or extend the period. On the other hand, the Supreme Court has the power to review the said proclamation and promulgate its decision thereon within 30 days from its filing. Pardoning power, amnesty. Number 20. The National Unification Commission has recommended the grant of absolute and unconditional amnesty to all rebels. There is the view that it is not necessary for the rebels to admit the commission of the crime charged, it being enough that the offense falls within the scope of the amnesty proclamation, following the doctrine laid down in Barrio Quinto vs. Fernandez, 82 Philosophy 642. In other words, admission of guilt is not a condition sine qua non for the availment of amnesty. Is this correct? Explain. Suggested answer. The view that it is not necessary for rebels to admit the commission of the crime charged in order to avail themselves of the benefits of amnesty is not correct. As stated in Vera v. People, 7 SCRA 156, the doctrine laid down in Barrio Quinto vs. Fernandez, 82 Philosophy 642 has been overturned. Amnesty presupposes the commission of a crime. It is inconsistent for someone to seek for forgiveness for a crime which he denies having committed. People vs. Pasillan, 14 SCRA 694. Pardoning power, amnesty. Number 5. Lucas, a ranking member of the NDF, was captured by policemen while about to board a passenger bus bound for Sorsogon. Charged with rebellion, he pleaded not guilty when arraigned. Before trial, he was granted absolute pardon by the President to allow him to participate in the peace talks between the government and the communist rebels. 3. Instead of a pardon, may the President grant the accused amnesty if favorably recommended by the National Amnesty Commission? Explain. 4. May the accused avail of the benefits of amnesty despite the fact that he continued to profess innocence? Explain. Suggested answer. 3. The President may grant the accused amnesty. According to Barrio Quinto vs. Fernandez, 82 Phil. 642, amnesty may be granted before or after the institution of the criminal prosecution. 4. No, the accused cannot avail of the benefits of amnesty if he continues to profess his innocence. In Vera vs. People, 7 SCRA 152. Since amnesty presupposes the commission of a crime, it is inconsistent for an accused to seek forgiveness for something which he claims he has not committed. Pardoning power, breach of condition, revocation. Bruno still had several years to serve on his sentence when he was conditionally pardoned by the president. Among the conditions imposed was that he would not again violate any of the penal laws of the Philippines. Bruno accepted all of the conditions and was released. Shortly thereafter, Bruno was charged with 2 counts of estafa. He was then incarcerated to serve the expired portion of his sentence following the revocation by the president of the pardon. Bruno's family filed a petition for habeas corpus, alleging that it was error to have him recommitted as the charges were false. In fact, half of them were already dismissed. Resolve the petition with reasons. Suggested answer. The petition should not be given due course. The grant of pardon and the determination of the terms and conditions of a conditional pardon are purely executive acts which are not subject to judicial scrutiny. The acceptance thereof by the convict or prisoner carried with it the authority or power of the executive to determine whether a condition or conditions of the pardon has or have been violated. Where the president opts to revoke the conditional pardon given, no judicial pronouncement of guilt of a subsequent crime is necessary, much less conviction therefore by final judgment of a court. In order that a convict may be recommended for the violation of his conditional pardon, the determination of the occurrence of a breach of a condition of a pardon, and the proper consequences of such breach, is a purely executive act, not subject to judicial scrutiny. Pardoning power, exec clemency, pardon. Number 5, Lucas, a ranking member of the NDF, was captured by policemen while about to board a passenger bus bound for Sorsogon. Charged with rebellion, he pleaded not guilty. When arraigned before trial, he was granted absolute pardon by the president to allow him to participate in the peace talks between the government and the communist rebels. Is the pardon of the president valid? Explain. Assuming that the pardon is valid, can Lucas reject it? Explain. Suggested answer. 1. The pardon is not valid. Under Section 19, Article 7 of the 1987 Constitution, pardon may be granted only after conviction by final judgment. 2. Yes, Lucas can reject the pardon as held in United States v.S. Wilson, 7 Pet 150 and Burdick v.S. United States, 274 U.S. 480. Acceptance is essential to complete the pardon, and the pardon may be rejected by the person to whom it is tendered, for it may inflict consequences of greater disgrace than those from which it purports to relieve. Alternative answer. No, Lucas cannot reject the pardon. According to Biddle vs. Perovich, 274 U.S. 480, acceptance is not necessary, for the grant of pardon involves a determination by the president that public welfare will be better served by inflicting less than what the judgment fixed. Pardoning power, executive clemency. Number 15, Governor A was charged administratively with oppression and was placed under preventive suspension from office during the pendency of his case. Found guilty of the charge, the president suspended him from office for 90 days. Later, the president granted him clemency by reducing the period of his suspension to the period he has already served. The vice-governor questioned the validity of the exercise of executive clemency on the ground that it could be granted only in criminal, not administrative, cases. How should the question be resolved? Suggested answer. The argument of the vice-governor should be rejected. As held in Lamas vs. Orbos, 202 SCRA 844. The power of executive clemency extends to administrative cases. In granting the power of executive clemency upon the President, Section 19, Article 7 of the Constitution does not distinguish between criminal and administrative cases. Section 19, Article 7 of the Constitution excludes impeachment cases, which are not criminal cases, from the scope of the power of executive clemency. If this power may be exercised only In criminal cases, it would have been unnecessary to exclude impeachment cases from this scope. If the President can grant pardons in criminal cases, with more reason he can grant executive clemency in administrative cases, which are less serious. Pardoning power, executive clemency. A. What are the constitutional limitations on the pardoning power of the President? B. Distinguish between pardon and amnesty. Suggested answer. A. The following are the limitations on the pardoning power of the President. 1. It cannot be granted in cases of impeachment. 2. Reprieves, commutations, pardon, and remission of fines and forfeitures can be granted only after conviction by final judgment. 3. The favorable recommendation of the Cumlic is required for violation of election laws, rules, and regulations. B. According to Barrio Quinto v. Fernandez, 82 Philosophy 642, the following are the distinctions between pardon and amnesty. 1. Pardon is a private act and must be pleaded and proved by the person pardoned, while amnesty is a public act of which courts take judicial notice. 2. Pardon does not require the concurrence of Congress, while amnesty requires the concurrence of Congress. 3. Pardon is granted to individuals, while amnesty is granted to classes of persons or communities. 4. Pardon may be granted for any offense, while amnesty is granted for political offenses. 5. Pardon is granted after final conviction, while amnesty may be granted at any time. And 6. Pardon looks forward and relieves the offender from the consequences of his offense, while amnesty looks backward and the person granted it stands before the law as though he had committed no offense. Pardoning power, kinds. Number 24. The first paragraph of Section 19 of Article 7 of the Constitution providing for the pardoning power of the President mentions reprieve, commutation, and pardon. Please define the three of them, and differentiate one from the others. Suggested answer. The terms were defined and distinguished from one another in People v. Vera, 65 Phil. 56, 100, and 11,112, as follows. Reprieve is a postponement of the execution of a sentence to a day certain. Commutation is a remission of a part of the punishment, a substitution of less penalty for the one originally imposed. A pardon, on the other hand, is an act of grace, proceeding from the power entrusted with the execution of the laws which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed. Pardoning power, pardon, conditional. Number 16. A. While serving imprisonment for estifa. Upon recommendation of the Board of Pardons and Parole, was granted pardon by the President on condition that he should not again violate any penal law of the land. Later, the Board of Pardons and Parole recommended to the President the cancellation of the pardon granted him because A had been charged with estifa on 20 counts and was convicted of the offense charged, although he took an appeal therefrom which was still pending. As recommended, the President cancelled the pardon he had granted to A. A was thus arrested and imprisoned to serve the balance of his sentence in the first case. A claimed in his petition for habeas corpus filed in court that his detention was illegal because he had not yet been convicted by final judgment and was not given a chance to be heard before he was recommitted to prison. Is A's argument valid? Suggested answer. The argument of A is not valid. As held in Torres vs. Gonzalez. 152 SCRA 272, a judicial pronouncement that a convict who was granted a pardon subject to the condition that he should not again violate any penal law is not necessary before he can be declared to have violated the condition of his pardon. Moreover, a hearing is not necessary before A can be recommitted to prison. By accepting the conditional pardon, A agreed that the determination by the President that he violated the condition of his pardon shall be conclusive upon him, and an order for his arrest should at once issue. President, participation, legislative process. Number 7. Can the President take active part in the legislative process? Explain. Suggested answer. Yes, the President can take active part in the legislative process to the extent allowed by the Constitution. He can address Congress at any time to propose the enactment of certain laws. He recommends the General Appropriations Bill. He can call a special session of Congress at any time. He can certify to the necessity of the immediate enactment of a bill to meet a public calamity or emergency. He can veto a bill. Presidential immunity from suit. Number 13. Upon complaint of the incumbent President of the Republic, A was charged with libel before the regional trial court. A moved to dismiss the information on the ground that the court had no jurisdiction over the offense charged because the President, being immune from suit, should also be disqualified from filing a case against A in court. Resolve the motion. Suggested answer. The motion should be denied according to Sullivan S. Makasior, 167 SCRA 393. The immunity of the President from suit is personal to the President. It may be invoked by the President only and not by any other person. Prohibition against multiple positions and additional compensation. Note 6. M is the Secretary of the Department of Finance. He is also an ex officio member of the Monetary Board of the Bangko Sentral ng Pilipinas, from which he receives an additional compensation for every board meeting attended. N, a taxpayer, filed a suit in court to declare Secretary M's membership in the Monetary Board and his receipt of additional compensation illegal and in violation of the Constitution. N invoked Article 7, Section 13 of the Constitution, which provides that the President, Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in the Constitution, hold any other office or employment during their tenure. N also cited Article IXB, Section 8 of the Constitution, which provides that no elective or appointive public officer or employee shall receive additional, double, or indirect compensation, unless specifically authorized by law. If you were the judge, how would you decide the following? A. The issue regarding the holding of multiple positions. B. The issue on the payment of additional or double compensation. Explain your answers fully. Suggested answer. If I were the judge, I would uphold the validity of the designation of Secretary M as ex officio member of the Monetary Board, as stated in Civil Liberties Union v. Executive Secretary, 194 SCRA 317, the prohibition against the holding of multiple positions by Cabinet members in Article 7. Section 13 of the Constitution does not apply to positions occupied in an ex officio capacity as provided by law and as required by the primary functions of their office. If I were the judge, I would rule that Secretary M cannot receive any additional compensation. As stated in Civil Liberties Union v. Executive Secretary, 194 SCRA 317, a cabinet member holding an ex officio position has no right to receive additional compensation, for his services in that position are already paid for by the compensation attached to his principal office. Prohibition against multiple positions by government officials. No, I assume that a law has been passed creating the Export Control Board composed of, see the Secretary of Trade and Industry as chairman and as members. The Chairman of the Senate Committee on Trade and Industry, an Associate Justice of the Supreme Court designated by the Chief Justice, D. the Commissioner of Customs, and T. the President of the Philippine Chamber of Commerce and Industry. The National Constitutional Association of the Philippines has filed suit to challenge the constitutionality of the law. Determine whether the membership of each of the above in the board can be upheld. Cite relevant constitutional provisions. Suggested answer. A. The chairmanship of the Secretary of Trade and Industry in the board can be upheld on the basis of Art. 9. B. Sector 7, which allows appointive officials to hold other offices if allowed by law or justified by the primary functions of their offices. The functions of the board is related to his functions as Secretary of Trade and Industry. The provision of Art. 7, seconds, 13, prohibiting cabinet members from holding any other office or employment, is subject to the exceptions in Art. 9, B, Sector 7. B. Dean Cinco believes that members of Congress cannot be members of the Board of Regents of the University of the Philippines under the Incompatibility Clause of the 1935 Constitution, which is similar to the provision of Art. 6, Sector 13 of the present Constitution. Under this view, the membership of the Chairman of the Senate Committee on Trade and Industry in the Export Control Board cannot be sustained. 5. Philippine Political Law 136, LLTH ed. 1962. Moreover, since the apparent justification for the membership of the Chairman of the Senate Committee is to aid him in his legislative functions, this purpose can easily be achieved through legislative investigations under Art. 6, Sector 21. On the other hand, Dean Cortez appears to suggest a contrary view, noting that after the decision in Government of the Philippine Islands v. Springer 50 Phil. 259, invalidating the law designating the Senate President and Speaker as members of the Board of Control of Government Corporations, no other decision has been rendered. On the contrary, laws have been enacted, making members of Congress members of various boards. Indeed, the membership of the Chairman of the Senate Committee on Trade and Industry may be upheld as being in aid of his legislative functions, since what is prohibited by Art. 6, Sector 13 is the acceptance of an incompatible office or employment in the government. The designation of an Associate Justice of the Supreme Court cannot be sustained, being the imposition on the members of the court of non-judicial duties, contrary to the principle of separation of powers. It is judicial power, and judicial power only, which the Supreme Court and its members may exercise. Art 8. Sector 1, Manila Electric Co. v. Paz A Transaction Co. 57 Phil. 600. The Commissioner of Customs may be made member of the board for the same. The membership of the President of the Philippine Chamber of Commerce may also be upheld on the ground that Congress has the power to prescribe qualifications for the office. Suspension of writ of habeas corpus. When may the privilege of the writ of habeas corpus be suspended? If validly declared, what would be the full consequences of such suspension? Suggested answer. Under Section 16, Article 7 of the Constitution, the privilege of the writ of habeas corpus may be suspended when there is an invasion or rebellion and public safety requires it. According to Section 18, Article 7 of the Constitution, the suspension of the privilege of the writ of habeas corpus shall apply only to persons judicially charged with rebellion or offenses inherent to or directly connected with invasion. Any person arrested or detained should be judicially charged within 3 days. Otherwise, he should be released. Moreover, under Section 13, Article 3 of the Constitution, the right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Article 8 Judicial Department. Cases to be heard en banc, Supreme Court. No. 11. Enumerate the cases required by the Constitution to be heard en banc by the Supreme Court. Suggested answer. The following are the cases required by the Constitution to be heard en banc by the Supreme Court. Cases involving the constitutionality of a treaty, international or executive agreement, or law. Cases which under the rules of court are required to be heard en banc. Cases involving the constitutionality, application, or operation of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations. Cases where a doctrine or principle of law previously laid down will be modified or reversed. Administrative cases against judges when the penalty is dismissal, and election contests for president or vice president. Contempt powers. Number 3, 2. On the first day of the trial of a rape-murder case where the victim was a popular TV star, over 100 of her fans rallied at the entrance of the courthouse, each carrying a placard demanding the conviction of the accused and the imposition of the death penalty on him. The rally was peaceful and did not disturb the proceedings of the case. A. Can the trial court order the dispersal of the rallyists under pain of being punished for contempt of court, if they fail to do so? Explain. B. If instead of a rally, the fans of the victim wrote letters to the newspaper editors demanding the conviction of the accused, can the trial court punish them for contempt? Explain. Suggested answer. 2A. Yes. The trial court can order the dispersal of the rally under pain of being cited for contempt. The purpose of the rally is to attempt to influence the administration of justice. As stated in People vs. Flores, 239 SCRA 83, any conduct by any party which tends to directly or indirectly impede, obstruct, or degrade the administration of justice is subject to the contempt powers of the court. B. No. The trial court cannot punish for contempt the fans of the victim who wrote letters to the newspaper editors asking for the conviction of the accused. Since the letters were not addressed to the judge and the publication of the letters occurred outside the court, the fans cannot be punished in the absence of a clear and present danger to the administration of justice. In Cabansag vs. Fernandez, 102 Phil 152, it was held that a party who wrote to the Presidential Complaints and Action Committee to complain about the delay in the disposition of his case could not be punished for contempt in the absence of a clear and present danger to the fair administration of justice. Finality of void judgments. Number 8. The ABC Realty, Inc. filed a complaint against Rico for the collection of unpaid installments on a subdivision lot purchased by the latter. Rico failed to file an answer, was declared in default, and after reception of plaintiff's evidence ex parte, judgment was rendered against him. The decision became final, and upon motion by ABC Realty, the judge issued a writ of execution. Rico now files a motion to quash the writ and to vacate the judgment, contending that it is the Housing and Land Use Regulatory Board which is vested with original and exclusive jurisdiction over cases involving the real estate business. Rico prays for the dismissal of the complaint and for the nullity of the decision. The realty firm opposes the motion, arguing that under BP 129, RTCs have exclusive and original jurisdiction over cases in which the amount of controversy exceeds P20,000. 00 Answer the following queries. 1. Who has jurisdiction over the collection suit? 2. The RDC decision, having become final and executory, can it still be vacated? Suggested answer. 1. The HLRB. 2. Yes, the decision of the regional trial court can still be vacated, even if it has become final and executory. Since the regional trial court had no jurisdiction over the case, the decision is void. Fiscal autonomy. No. 11. What do you understand by the mandate of the Constitution that the judiciary shall enjoy fiscal autonomy? Cite the constitutional provisions calculated to bring about the realization of the said constitutional mandate. Suggested answer. Under Section 3, Article 8 of the Constitution, the fiscal autonomy of the judiciary means that appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year and, after approval, shall be automatically and regularly released. In Bengtson v. Jaclyn, 208 SCRA 133, the Supreme Court explained that fiscal autonomy contemplates a guarantee of full flexibility to allocate and utilize resources with the wisdom and dispatch that the needs require. It recognizes the power and authority to deny, assess, and collect fees, fix rates of compensation not exceeding the highest rates authorized by law for compensation and pay plans of the government, and allocate and disperse such sums as may be provided by law or prescribed by it in the course of the discharge of its functions. Function: continuing constitutional convention. No. One senator remarked that the Supreme Court is a continuing constitutional convention. Do you agree? Explain. Suggested answer. I do not agree that the Supreme Court is a continuing constitutional convention. The criticism is based on the assumption that in exercising its power of judicial review, the Supreme Court is not merely interpreting the Constitution but is trying to remake the government on the basis of the personal predilections of the members of the Supreme Court. This is a power that properly belongs to the people and their elected representatives. The Supreme Court cannot decide cases merely on the basis of the letter of the Constitution. It has to interpret the Constitution to give effect to the intent of its framers and of the people adopting it. In interpreting the Constitution, the Supreme Court has to adopt it to the ever-changing circumstances of society. When the Supreme Court strikes down an act of the legislative or the executive department, it is merely discharging its duty under the Constitution to determine conflicting claims of authority. Alternative answer. To a certain extent, the Supreme Court is a continuing constitutional convention. When a case is brought in court involving a constitutional issue, it becomes necessary to interpret the Constitution. Since the Supreme Court is supreme within its own sphere, its interpretation of the Constitution will form part of the law of the land. Issuance of restraining orders and injunctions. Number 7. Congress is considering new measures to encourage foreign corporations to bring their investments to the Philippines. Congress has found that foreign investments are deterred by the uncertain investment climate in the Philippines. One source of such uncertainty is the heightened judicial intervention in investment matters. One such measure provides that no court or administrative agency shall issue any restraining order or injunction against the central bank in the bank's exercise of its regulatory power over specific foreign exchange transactions. Would this be a valid measure? Explain. Suggested answer. Yes, the measure is valid. In Mantrust Systems, Inc. vs. Court of Appeals, 179 SCRA 136, the Supreme Court held that a law prohibiting the issuance of an injunction is valid, because under Section 2, Article 8 of the Constitution, the jurisdiction of the courts may be defined by law. Alternative answer. Since under Sections 1 and 5, Article 8 of the Constitution, the courts are given the power of judicial review, the measure is void, such power must be preserved. The issuance of restraining orders and injunctions is in aid of the power of judicial review. Judicial and Bar Council. Number 11. A novel feature of the present Constitution is the Judicial and Bar Council. Please state. 1. Its principal function, 2. Its composition, and 3. Who supervises it, and takes care of its appropriations. Suggested answer. 1. The Judicial and Bar Council has the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. 2. The JBC is composed of the Chief Justice as ex officio chairman, the Secretary of Justice and a representative of the Congress as ex officio members, a representative of the Integrated Bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. 3. The Supreme Court supervises the JBC and provides in the annual budget of the court the appropriations of the JBC. Judicial and Bar Council. No. 11. What is the composition of the Judicial and Bar Council and the term of office of its regular members? Suggested answer. The Judicial and Bar Council is composed of the following. 1. The Chief Justice as ex officio chairman. 1. The Secretary of Justice as ex officio member, 2. A representative of Congress as ex officio member, 3. A representative of the Integrated Bar, 4. A professor of law, 5. A retired justice of the Supreme Court, and 6. A representative of the private sector. Section 8. Article 8 of the Constitution. The term of office of the regular members is 4 years. Article 8 of the Constitution. Judicial Department, Writ of Amparo. Number 1. What is a constitutional writ of amparo and what is the basis for such a remedy under the Constitution? Suggested answer. The writ of amparo in Mexican law is an extraordinary remedy whereby an interested party may seek the invalidation of any executive, legislative or judicial act deemed in violation of a fundamental right. The adoption of such a remedy in the Philippines may be based on Article 8, Sector 5 of the Constitution, which empowers the Supreme Court to promulgate rules concerning the protection and enforcement of constitutional rights. Judicial independence, safeguard. No, I name at least 3 constitutional safeguards to maintain judicial independence. Suggested answer. The following are the constitutional safeguards to maintain judicial independence. The Supreme Court is a constitutional body and cannot be abolished by mere legislation. The members of the Supreme Court cannot be removed except by impeachment. The Supreme Court cannot be deprived of its minimum jurisdiction prescribed in Section 5, Article X of the Constitution. The appellate jurisdiction of the Supreme Court cannot be increased by law without its advice and concurrence. Appointees to the judiciary are nominated by the Judicial and Bar Council and are not subject to confirmation by the Commission on Appointments. The Supreme Court has administrative supervision over all lower courts and their personnel. The Supreme Court has exclusive power to discipline judges of lower courts. The members of the judiciary have security of tenure, which cannot be undermined by a law reorganizing the judiciary. Members of the judiciary cannot be designated to any agency performing quasi-judicial or administrative functions. The salaries of members of the judiciary cannot be decreased during their continuance in office. The judiciary has fiscal autonomy. The Supreme Court has exclusive power to promulgate rules of pleading, practice, and procedure. Only the Supreme Court can temporarily assign judges to other stations. It is the Supreme Court who appoints all officials and employees of the judiciary. Judicial power. Number 10. Where is judicial power vested? What are included in such power? Suggested answer. According to Section 1, Article 8 of the 1987 Constitution, judicial power is vested in one Supreme Court and in such lower courts as may be established by law. It includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Judicial power. Number 8. A case was filed before the Sandiganbayan regarding a questionable government transaction. In the course of the proceedings, newspapers linked the name of Senator J. De Leon to the scandal. Senator De Leon took the floor of the Senate to speak on a matter of personal privilege to vindicate his honor against those baseless and malicious allegations. The matter was referred to the Committee on Accountability of Public Officers, which proceeded to conduct a legislative inquiry. The committee asked Mr. Vince Ledesma, a businessman linked to the transaction and now a respondent before the Sandiganbayan, to appear and to testify before the committee. Mr. Ledesma refuses to appear and file suit before the Supreme Court to challenge the legality of the proceedings before the committee. He also asks whether the committee had the power to require him to testify, identify the issues involved and resolve them. Suggested answer. The issues involved in this case are the following. 1. Whether or not the Supreme Court has jurisdiction to entertain the case. 2. Whether or not the Committee on Accountability of Public Officers has the power to investigate a matter which is involved in a case pending in court. And 3. Whether or not the petitioner can invoke his right against self-incrimination. All these issues were resolved in the case of Bengzon vs. Senate Blue Ribbon Committee, 203 SCRA 767. The Supreme Court has jurisdiction over the case, because it involves the question of whether or not the Committee on Accountability of Public Officers has the power to conduct the investigation. Under Section 1, Article 8 of the Constitution, judicial power includes the duty of the courts to determine whether or not any branch of the government is acting with grave abuse of discretion amounting to lack of jurisdiction. The Committee on Accountability of Public Officers has no power to investigate the scandal. Since the scandal is involved in a case pending in court, the investigation will encroach upon the exclusive domain of the court. To allow the investigation will create the possibility of conflicting judgments between the committee and the court. If the decision of the committee were reached before that of the court, it might influence the judgment of the court. The petitioner can invoke his right against self-incrimination. Judicial power. 4. Andres Ang was born of a Chinese father and a Filipino mother in Sorsogon, Sorsogon, on January 20, 1973. In 1988, his father was naturalized as a Filipino citizen. On May 11, 1998, Andres Ang was elected representative of the 1st District of Sorsogon. Juan Bonto, who received the second highest number of votes, filed a petition for quo warranto against Ang. The petition was filed with the House of Representative Electoral Tribunal. Bonto contends that Ang is not a natural-born citizen of the Philippines and therefore is disqualified to be a member of the House. The HRET ruled in favor of Ang. Bonto filed a petition for certiorari in the Supreme Court. The following issues are raised. 1. Whether the case is justiciable considering that Article 6, Section 17 of the Constitution declares the HRET to be the sole judge of all contests relating to the election returns and disqualifications of members of the House of Representatives. 2. Whether Ang is a natural-born citizen of the Philippines. 5%. How should this case be decided? Suggested answer. 1. The case is justiciable. As stated in Lazaden vs. House Electoral Tribunal 168 SCRA 391, 404. Since judicial power includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, the Supreme Court has the power to review the decisions of the House of Representatives Electoral Tribunal in case of grave abuse of discretion on its part. 2. Sasaeng should be considered a natural-born citizen of the Philippines. Judicial power, scope. Number 2. 1. What is the difference, if any, between the scope of judicial power under the 1987 Constitution on one hand, and the 1935 and 1973 Constitutions on the other? Suggested answer. The scope of judicial power under the 1987 Constitution is broader than its scope under the 1935 and 1973 Constitution because of the second paragraph of Section 1, Article 8 of the 1987 Constitution, which states that it includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, as held in Marcos Us. Manglapus, 177 SCRA 668. This provision limits resort to the political question doctrine and broadens the scope of juridical inquiry into areas which the courts under the 1935 and the 1973 constitutions would normally have left to the political departments to decide. Alternative answer. Under the 1935 and 1973 constitutions, there was no provision defining the scope of judicial power as vested in the judiciary. While these constitutions, both provided for vesture of judicial power in one Supreme Court and in such inferior courts as may be established by law, they were silent as to the scope of such power. The 1987 Constitution, on the other hand, rewrote the provisions on the vesture of judicial power originally appearing in the 1935 and 1973 constitutions, as follows. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The second paragraph of the cited provision was not found in the 1935 and 1973 Constitution. It contains a new definition of judicial power, particularly the scope thereof. The first portion thereof represents the traditional concept of judicial power, involving the settlement of conflicting rights as by law, which presumably was implicit in the 1935 and 1973 constitutions. The second portion of the definition represents a broadening of the scope of judicial power or, in the language of the Supreme Court, conferment of expanded jurisdiction on the judiciary, Das v. Singson, 180 SCRA 496, to enable the courts to review the exercise of discretion by the political departments of government. This new prerogative of the judiciary as now recognized under the 1987 Constitution was not constitutionally permissible under the 1935 and 1973 charters. Judicial review, locus standi. Number 6, the Philippine Environmentalists. Organization for Nature, a duly recognized non-governmental organization. Intends to file suit to enjoin the Philippine government from allocating funds to operate a power plant at Mount Tuba in a southern island. They claim that there was no consultation with the indigenous cultural community which will be displaced from ancestral lands essential to their livelihood and indispensable to their religious practices. The organization is based in Makati. All its officers live and work in Makati. Not one of its officers or members belong to the affected indigenous cultural community. Do they have the standing in this dispute? Explain. D. Would your answer be different if the Philippine Power Corporation, a private company, were to operate the plant? Explain. Suggested answer. A. Under Section 5, Article 12 of the Constitution, the state should protect the rights of cultural indigenous communities to their ancestral lands to ensure their well-being. Under Section 17, Article 14 of the Constitution, the state should protect the rights of indigenous cultural communities to preserve and develop these cultures, traditions, and institutions, and should consider these rights in the formulation of national plans and policies. The government violated these provisions because it decided to operate the power plant without consulting the indigenous cultural community, and the operation of the power plant will result in its displacement. If the projected lawsuit will be based on violation of the rights of the indigenous cultural communities, the Philippine Environmentalists Organization will have no standing to file the case. None of its officers and members belong to the indigenous cultural community. None of their rights are affected. If the lawsuit will seek to enjoin the use of public funds to operate the power plant, the Philippine Environmentalists Organization can file a taxpayer's suit. As held in Masada Us. Macarade, 197 SCRA 771, a taxpayer has standing to question the illegal expenditure of public funds. B. The Philippine Environmentalists Organization will have no standing to file the case if it is a private company that will operate the power plant, because no public funds will be spent for its operation. As held in Gonzales vs. Marcos, 65 SCRA 624, a taxpayer has no standing to file a case if no expenditure of public funds is involved. Since no member or officer of the Philippine Environmentalists Organization belongs to the affected indigenous community, none of the rights of the Philippine Environmentalists Organization and of its officers and members are affected. In accordance with the ruling in National Economic Protectionism Association vs. Ongpan, 171 SCRA 657, the organization has no standing to file the case. Judicial Review, Requisites. Number 2. Assume that the constitutional question raised in a petition before the Supreme Court is the iis mota of the case. Give at least 2 other requirements before the court will exercise its power of judicial review. Suggested answer. 2. According to Macasiano vs. National Housing Authority, 224 SCRA 236, in addition to the requirement that the constitutional question raised be the lis mota of the case, the following requisites must be present for the exercise of the power of judicial review. 1. The must be an actual case or controversy involving a conflict of legal rights susceptible of judicial determination. 2. The constitutional question must be raised by the proper party. And 3. The constitutional question must be raised at the earliest opportunity. Jurisdiction of blurb.